Please, Your Lordship. My Lord, in respect to item number 32 fixed yesterday for today regarding the Standing Counsel Guwahati High Court,
Yes.
The order sheet reveals that the government advocate had initially appeared for the District and Session Judge Lakhimpur, which he ought not to have done. And Lord, I pray that I may be permitted to serve a copy on the registry and they will allot the particular file to one among the panel of the Standing Councils of the Guwahati. 32 supplementary. Yesterday it was fixed by Lordship and it has appeared today. If I'm not supplementary item.
Supplementary item number?
I'm sorry, Madam, 38.
38.
38.
Sir, Edward Lord submits that may be permitted to serve a copy of the notice with the registry of this court so that they can endorse one standing counsel enter appearance in the present. Pair of the photo is allowed. This is the number
2 weeks. Complied.
Item number 10 and 11. I'm for a petition on behalf of Mr. Asbotabo. Second from that asset. Mr. become in fact.
in fact. Sir, Gogo attorney counsel, your name is not there.
Yes, sir. On behalf of Mr. Asbotabo.
I'm here, my lord, for the BTC, my lord.
Okay.
BTC,
No.
respondent.
I'm on behalf of Mr. Asbotabo.
What have attorney counsel attorney subject according
Deeply honored.
I beg your lordship permission, my lord, for listing one writ petition, my lord, pertaining to pension matter. I have approached the author registry, my lord, but it is not listed.
to the senior court, court number 4.
My lord,
Court number 4.
court number 4. Correct.
May please, your lordship. I pray for listing of a part third matter. Your lordship is hearing the matter, my lord. It was last listed on 13/6, my lord. Any that in any that before, my lord, vacation, my lord. This thing.
Hearing
I say admission matter. Your lordship is hearing the matter. It's part third matter, my lord. Before vacation, any date, my lord. 20. Highly of that.
On 28/8/2025, this matter was directed to be listed for admission today. For disposal. But why again it has been listed for my lord? On 28/8/2025, this matter was listed for referral to the mediation tribe, my lord. My lord, it is a case, my lord, where the admitted case is that, my lord, due to some documents which are missing in the office of the department, the petitioner is not given the benefit. It is not that they are disputing my entitlement. So she can dispose of this matter, my lord. It should have been listed for admission. As my lord, on 28/8, my lord, it was directed to be listed for admission, my lord.
if you were ready to argue the matter, argue. Well, all the respondents are present.
Otherwise, this matter is for referral lordship. There is no dispute as regard the claim of the petitioner. The only thing is that some document has to be uploaded through that Gata portal that could not have been done. So they will sort out in the mediation and things will work. Otherwise, it is a fit case for referral lordship.
Fit case.
Lordship.
My lord,
And in fact, on the last occasion, my learned, Since junior appeared for obtaining instruction as to my learned friend was not there on the last occasion, and his junior appeared,
Possibly
and
kindly turn to page 39. Page 39, my lord. Here, my lord,
and we have not yet filed
name
our
of three
affidavit.
persons are there. Three
I have
persons are
received,
there.
I have received
Are you
instruction.
ready to argue the matter?
No, Lordship.
No.
Today, no. Sir. Otherwise, if my learned friend wants to argue, then let it be fixed for admission on some other day. In the meantime, we will file our affidavit. I have received instruction. If my learned friend agrees, then it is fit for referral.
Three persons were there. Two persons approached the authority. They have been paid. Only the petitioner is late because he has approached this court. This is not the way to treat the employees of the government. By.
No, that's all right. Are you agreeable to refer the matter to the?
No, my lord. Lordship can decide this matter. Lordship will decide this matter
Then Lordship
Okay.
fix up
in the next week, my lord.
after vacation, Lord. In the meantime, we will file our affidavit.
Nothing is left in this issue. In this case, my lord, they have admitted that petitioner is entitled to the MSCP, third MSCP. Order was passed after retirement. Only the benefit is not given. That is the only thing they have to give. I don't know why the
Lordship, may I read one pair of my instruction? Lordship will come to know, Lordship, what has actually happened. As reported by the DO Kamrup at Amingaon, violated dated 22/4/2025, the petitioner had also applied for commutation of pension, and DO concerned has submitted the proposal to the Director of Pension, Assam, through Kritagata portal on 1/8/2020. The petitioner has already received the commuted value of pension through Treasury Office Kamrup Amingaon, but the revision due to commutation has not been updated on Kritagata portal by concerned authority, that is the Director of Pension Assam, due to which the revision due to MSCPs could not be submitted by DO Kamrup Amingaon through Kirtagata portal, as the next revision proposal could not be proceeded unless completion of the processing of previous revision. So there is only that technical issue. That technical issue could have been sorted out once the matter is referred in the mediation, and the concerned department authority will take care of the whole thing.
So I think but hard I
Respondent 5. Okay.
Five. Uh,
Obliged.
can it be viewed vacation, man? Can it be viewed
After
vacation, man? It is admitted case, man. They have admitted. Only the updation in the Kirtagata portal is required.
That is
so vacation also method करते हैं.
after vacation, Lord.
There is nothing to decide in this case.
Last
In
week
fact, my
we- last
motion, the last week will be motion.
Obliged.
the meantime,
Lordship.
may file
In that
Lord,
case, Lordship will fix
will
the matter, my lord, on 24th, my lord. 22nd. 2nd October.
Obliged.
Obliged.
Lord, if Lordship permits, sir, earlier notices have been issued to respondent number 2 and 4, Lord. Respondent number 4, Lord, the name was not correctly implemented in the Lord case. And that's why after taking inspection, we have Lord provided the correct name. And that's how this application has come before your lot.
PC remedy.
2 and 4, my lord. I'll also be appearing for 4, my lord, presently implicated.
Number 24. Number 4. In the context how it was
Lord, it was earlier designation was same, Lord, but some other person's name was incorporated, Lord, in the main petition.
right. But they bother secret would have been allowed to learn or and for some set object of taking some part of they bother secret which is number 4 in place of the concept for 9 5 of the order of the learned for the one
My lord may grant me 2 weeks time to file, my lord, in respect of respondent number 2, my lord. My lord, the affidavit is to be, my lord, vetted. But in a week or 2, my lord, we will file our affidavit.
the meantime sir to pay learned
File. Deeply.
Wait, please, Your Lordship. Lordship, in this matter, we have filed our affidavit today, my lord. My lord, we have filed our affidavit, bringing on record the 3, my lord, enclosures, which Your Lordship had asked us to bring. 3 of the enclosures have been got. So, my lord will, since it's not on record, Lordship will fix some other date, my lord.
Lordship, before vacation, any
Before
within the
vacation,
short-
any date, my lord. Then, my lord can proceed to produce.
or means
age barrier.
learned
Yes, Lordship.
part but additional
Page 37. Page 37 written.
after a bit the
Interpret. Should be able.
In this, I have filed my one application, say affidavit. completing some documents, that is the called select list of illegal teachers. My learned friend was also directed to produce that original select list.
The original select list also.
And in the original,
When did you file the affidavit?
I have filed on 1st of November, Monday.
First of-
My lord. Here, in the record, I have check out in the morning, my lord. Today, my lord. So that is there, my lord. Having these, my lord, both के पेज होते हो? Oh, the bulk here. आपके copy दो. अरे, बहुत देर के लिए. Lord, my submission will say this is the list of illegal teachers of Coringo. I have filed an RTI, and on the basis of that RTI, they have given me. And in this list, my name is not there. If I ever will not illegal teacher, my name they have been listed in this list. But no name. So, from that point of view, also, I am legal. And on the same date, 27/10/99, my name got selected. I have selected serial number 35. Now they are saying that I am not selected.
Lordship,
That is their claim.
May I pray,
My
Lordship,
submission
because-
says I am selected, I am working, and I also the my service salary was given to the treasury, but the salary was not paid to me.
Lordship,
So
by
I
way of
filed.
this additional affidavit, my learned friend has brought on record certain documents, the list, Lordship. So in that regard also, I have to obtain instruction, Lordship. So Lordship may fix immediately after vacation. In the meantime, we will,
Not ready to argue the matter.
today,
You are
not
not ready.
ready, Lord. Because Lordship has also directed to produce me that original select list.
Yes.
And that select list also, apparently they have sent. But yesterday I could not trace in the office also, Lordship. So, and in the meantime, this affidavit, my learned friend has brought on record certain other documents. So in regard to get the clarification of these documents also, Lordship may fix immediately after vacation, Lordship. In the meantime, I will produce that original select list. That
Before
of
vacation,
99?
that is not very short.
Or-
Select or not select. That is the only two questions.
Lordship,
Other than selected or unselected, that is the main.
Lordship.
Nothing is-
Sir, nothing started.
Huh?
It is so to be.
How about it? I didn't copy the link.
No, no.
Has filed for the document and
Can we have 17 minutes, 17 this month?
Immediately after.
Well, yeah, I am thinking this month
No, no. October, 17th October.
as a part of melody.
Lordship, as per Lordship direction, I have brought the judgment on record through affidavit. It's in the process of filing today. Lordship may take up this matter next week, Lordship.
after
Next week, Lordship. It's in the process of filing today, Lordship.
but I don't have got the
I have gone through the judgment, my lord, and and in the judgment, in the last part, that uh, court observed that the first regulation, that is on 2015, from which the petitioner claiming their salary, my lord, they are not in a substantive. And the second regulation, that is on 2022, and from that their petitioner receiving their regular salary. But the thing is that the first regulation order, that is on 2015, and That regulation order, there is not mentioned that their petitioner was appointed in a non-substantive post. And on the good faith of this regulation order, the petitioner is continuously working in as an assistant teacher in their respective school.
So that's right, but how are of
Those rich petitions where the numbers of petitioner, they did not get the salary from the beginning. After appointment in the petitioner received their salary from the date of joining till 2009. And 2009, their service were terminated from the post. Thereafter, on the basis of the writ appeal on the High Court order, they are reinstated in the 2015. That is the first regulation order. And first regulation order, they was joined in their respective school and they are continuing in their school, but they did not get their monthly salary. On 2020-22, the respondent authority again issued a different regulation order, for which from that order, they have received their monthly salary. They were, after that, receiving the monthly salary, they filed a present writ petition for the non-payment of arrear salary, that is from the period of 2015 to 2020. And in that last numbers of writ petition, there are various writ petitioners who did not get any salary from the beginning, right? From 2015 till date. So my case is little bit different. They are receiving salary from 2020.
okay, the
Yes.
part a go to
Pujar Bora.
after one by the record of putting events of the
It may be six pilot.
May I please, your lordship. Lordship, in this matter, affidavit has been sent for vetting, lordship. It will be filed by Tuesday or Wednesday, lordship.
you are for
APSC, lordship, respondent number 3.
art
Article.
art of
Complete.
there
Yes, lordship.
art
P. Sharma, lordship. APSC, lordship.
APS
Respondent 3.
APS and after vacation
Right, please, Your Lordship. Lordship, and in this case, regarding selection and appointment for the post of junior assistant in Krishna Higher Secondary School. What had happened in this case, my lord? Initially, an advertisement was issued on 8/12/2015, and subsequently the written test as well as the viva voce test was done and selected one person, namely Makoni Begum. But that was challenged before this honorable board, on the ground of favoritism and nepotism. And subsequently, this Honorable Court, by common judgment and order dated 31/7/2018, which is at page 27, it set aside the state selection process with a direction to issue a fresh advertisement. And accordingly, the 30/10/2019, the fresh advertisement was issued. That advertisement, my lord, is at page 33.
Second, ready to argue the matter?
Otherwise, we have filed our affidavit.
Proceedings is extensive.
Extent.
Yes, matter is for 2020. My lord, kindly peruse the order dated 18/3/2025. The
And all the attorney and court for
I am appearing for 1, 2, and 5, my lord.
1, 5. And I don't for a bit for and for 6 and 7. So the notice was served on the
top man.
Yes, make a note on it. Just go, make a note.
Notice was served, my lord, but they did not represent, my lord.
attorney for ready to argue the matter.
Yes, my lord. Otherwise, I am ready, my lord.
My lord, thereafter, the fresh advertisement was issued on 30/10/2019, my lord, page 33.
What is the advertisement?
Page 33. Applications are invited in prescribed format for eligible candidates for filling up one lower division assistant of permanent residence at Krishnai Higher Secondary Madrasa School, Krishnai. Qualification HS pass or equivalent and having diploma in English and Assamese computer. Last date of submission of application 15/11/2019 as per the guideline. And which was, my lord, subsequently extended up to 15/12/2019 by issued an corrigendum notice, which was is at page 36. The extension inclusion of date of submission of application forms for the post of lower division assistant in Krishna Higher Secondary Madrasa School pursuant to the advertisement published on 30/10/2019, and the same has been extended up to 15/12/2019. The age limit of the candidate should be in accordance with the government guidelines, and the post is unreserved. The candidate should be a citizen. And thereafter, the petitioner as well as the some other eligible candidate applied for the state post. And accordingly, an admit card was issued to the petitioner is at page 39 for written examination. The admit card was issued on 26/2/2020. Written test for selected candidates for the post of junior assistant. A written test for selection of candidate for the post of junior assistant will be held at Krishnai Madrasa SS School, Krishnai on 8 March 2020 at 11 a.m. as per the criteria mentioned in the advertisement dated 30 October 2019. Therefore, you are hereby asked to appear in the written test at the venue and time as mentioned above. Accordingly, the petitioner along with other eligible candidates participated in the written examination, and the result of the written examination was published on 8/3/2020 itself. And the top 10 candidates list has been published, which is at page 43. And the petitioner stood first.
Yes.
But the page 43, the name of the petitioner reflected at serial number 1, Mohammad Nadim. Thereafter, due to the COVID-19, the computer typewriting as well as the vibration test could not be held. And subsequently, on 2/9/2020, the inspector of schools issued a direction to the principal of the Krishna Higher Secondary School for conducting the computer as well as the vibration test. And the said letter is at page 45. Got it? Page 45.
Annexure 7.
Annexure 7. And pursuant to the said letter, the principal of the school issued calling letter to the petitioner, which is at page 48, for holding the computer as well as the oral test for selection of the said post, and which was supposed to be held on 31st October 2020, which is at page 48. And the said calling letter was received by the petitioner on 27th of October. But surprisingly, on 30/10/2020, the principal issued a notice by which postponed the computer as well as the vibration test until further order. This input notice has been issued on 30/10/2020, and the test was supposed to be held on 31/10/2020, which is at page 49. Suddenly, this notice has been issued. And after query, the petitioner came to know that this notice has been issued pursuant to the direction of the Additional Deputy Commissioner Gwalpara, which is at page 51. Issued on 28/10/2020 regarding appointment and posting at Krishna Madrasa Higher Secondary School. With reference to the subject cited above, I am directed to request you to stop all kinds of appointment and posting related activity pending in Krishna Madrasa Higher Secondary School, Gwalpara, with immediate effect. And pursuant to these letter, the Inspector of Schools also issued a letter on 29/10/2020, which is at page 53.
Yes.
Pursuant to this letter, the import notice which has been issued. And thereafter, the petitioners challenged these one notice and the 2 letters issued by the concerned authority. And during the pendency of this case, the Deputy Commissioner filed an affidavit in opposition, which is at page 58, running page, page 58, by the respondent number 3. In the meanwhile, what had happened, one thing, the suddenly one assistant commissioner has came to the school of the Krishna Higher Secondary and called the petitioner in the office of the principal, and when he reached there, the magistrate has given a question paper which was he written in 7 months back, and to answer the same, the petitioner nervous and he could not answer properly in that case, my lord. And on the basis of that, my lord, they have submitted a inquiry report which is at page 61, running page, my lord. And this inquiry has been conducted. As per the inquiry, the complaint submitted by some persons who are not even participated in the selection process and some unsuccessful candidates. The page 61 is the report, submitted on 30/11/2020. The relevant portion, the report, next, a field inspection. Page 61, got it?
Yeah.
A field inspection was performed on 27/10/2020 at Krishna Madrasa SS School, and Mohammad Nadim was called, that is the petitioner, to the spot. He was asked to write the same question paper that he wrote on 8/3/2020. His scores was only 16.50 out of 80 on 27/10/2020. Observation: as the candidate Mohammad Nadim got only 16.50 marks out of 80, his score in the main test of 70 on 8/3/2020 is very doubtful. Although the test was conducted on the same question paper after 7 months, his excessive low score 16.50 as against his exceptionally high score is not acceptable. There may be illegal ways employed for his exceptionally high score in the written test, as there were neither any syllabus specified in the advertisement nor the question paper was easy. As there is a huge difference in between the Mohammad Nadim's obtained score and so on two different dates, a definite doubt arises regarding his exceptional high score in written test held on 8/3/2020. Mohammad Nadim's qualification is BA with 44% score. The undersigned is of the view that benefit of doubt should not be given to Mohammad Nadim. A retest should be conducted under supervision of the Honorable Deputy Commissioner Gwalpara. Written test should be conducted in a place outside Krishna, preferably in Gwalpara, and question paper should be set out under the supervision of Deputy Commissioner Gwalpara. And what had happened, my lord, the inquiry simply just asked the petitioner suddenly after 7 months and give him the question paper which he wrote it 7 months back. He could not properly answer. That is the only basis of the inquiry, by saying that he maybe has obtained the unfair means he have done in the examination. Regarding the examination, my lord, the inspector of schools has filed also affidavit in opposition. My lord. Can we take up, my lord, page 74 of the running page, my lord. And the relevant portion, this affidavit was filed by the inspector of schools, my lord. Page 77, my lord, running page. Para 11. My lord, got it? That the deponent humbly begs to state that in the meantime, the aggrieved candidates have filed a complaint petition against the written test of LDA Junior Assistant of Krishna Madrasa SS School. And so, the then Inspector of School GDC Gwalpara by letter dated 9/10/2020 directed the principal cum member secretary of the selection committee of Krishna Madrasa SS School to submit a detailed report on the complaint. Accordingly, a detailed report dated 2010/2020 was submitted by the principal of Krishna Madrasa SS School, stating that the written test was done smoothly under the vigilance of the supervising officer and the inspector of school GDC Gwalpara. Here, the inspector of school clarified that no such anomalies, no impairment has been done in the written test examination held on 8/3/2021. Thereafter, my lord, the another aspect has come up in this case, my lord. In the meanwhile, the the Assam Direct Recruitment Commission for analogous post in class 3 and class 4, an advertisement was issued, which was not known to the petitioner, my lord. During the course of the admission hearing in the case, my lord, the Learned Standing Council has informed that one person has already been appointed against the said post. And immediately, the petitioner challenged the said appointment, my lord, by filing an WPC number 544/2023, my lord. My lord, sorry, my lord, 655/2023. And after filing this petition, my lord, this honorable court was pleased to issue notice upon the respondents, my lord, with an observation that the appointment of the private respondent is subject to the outcome of the state petition, my lord. The which order is at page 108, my lord, running to of my additional affidavit. All got it?
Yes.
And the relevant portion is at page 110, my lord. The order dated 15/11/2023. In this application, the petitioner has challenged the order dated 25/5/2023 issued by the Inspector of School, Gwalpara District Circle, District Gwalpara, appointing the respondent number 8 as Junior Assistant Grade 3 of the Provincialized Secondary School under Gwalpara District. It is the case of the petitioner that the respondent number 8 has been appointed in the state post and is presently serving as Krishna SSC School, Gwalpara. Mr. So-and-so, elementary education appears for respondent number 1, 2, and 5, and so-and-so advocate appeared for the respondent number 3 and 4. The learned counsel for the petitioner shall serve the requisite copy of the so-and-so. While at the last observation, it is made clear that the appointment of the respondent number 8 shall be subject to the outcome of the state petition. And after receiving the notice of this petition, my lord, the private respondent entered her appearance in this case and also filed an affidavit in opposition. But subsequently, on 10/5/2024, which is at page 111, she resigned from the post. And the same was already accepted. Page 111 to the principal, Krishnai High Secondary School, Krishnai, dated the principal so-and-so. With due respect, I have the honor to inform you that I am a junior assistant in Krishnai High Secondary School. I am not interested to serve as a junior assistant of the state school due to my personal matters. In this regard, I have submitted my resignation letter from the service with effect from 10/5/2024 and request you to accept my resignation letter from today. And since then, the said post is lying vacant till date. Now, my lord, we come to the advertisement, page 103, my lord. The subsequent advertisement issued centrally for all the departments, wherein the specification of the post has not been mentioned, neither the post of the petitioner, which is under challenge, has been mentioned. Page 103. This is the advertisement published on 1/3/2022. In exercise of power conferred by the Assam Direct Recruitment Commission for analogous posts in Class 3 and Class 4 Act 2021, online application are invited from the intending and eligible candidates who are citizens of India having registration number in employment exchange in the state of Assam, filling up so and so post numbers of vacant grade 3 post tentative under different establishment department under the Gov. That is the advertisement under which the appointment of the private respondent was done. Here in this case, the advertisement, the petitioner could not be challenged. That submission was raised from my learned friend that the advertisement has to be challenged since the advertisement has been subsequently issued. But in fact, the post against which the petitioner was completed a written examination has not been mentioned here. And more particularly, the advertisement was issued pursuant to the Act of 2021. My lord, kindly come to page 115 of my additional report. This is the act, my lord. Pursuant to this act, the advertisement was issued. My lord, kindly come to the relevant portion, section 21, my lord, at page 125. 125. My lord, got it? My lord, kindly see the section 21, bottom, my lord, repeal and savings. The provisions of direct recruitment incorporated in any rules or orders in respect of the class 3 and class 4 posts other than such posts which are excluded from the purview of this act under section 3 are hereby repealed, provided that any recruitment process for which advertisement have been issued or which is at any stage of recruitment shall be completed as per the existing provisions under which the advertisement were made. Prior to that, this post was already been advertised on 30/10/2019, and pursuant to that advertisement, the process was going on. And the earlier advertisement was issued pursuant to the 2003 rules. So, as per this section 21, the process which was initiated pursuant to the earlier advertisement has to be completed, my lord. Now, my lord, my first leg of argument is that since as per the 2003 rules, the Deputy Commissioner has no authority to interfere into the selection process initiated under 2003 rules by the Inspector of School and the Selection Committee of the concerned schools, my lord. And to that effect, my lord, I rely upon a judgment of these honorable court, my lord, which was reported in 2017 to GLJ 451. My lord, in this judgment, kindly come to para 8, my lord. Para 8, the post of LDA, which has now been redesignated as junior assistant, is included in class 3 of Assam Secondary Education Provincial Service as defined under Rule 2S of the Assam Secondary Education Provincial Service Rule 2003, read with Rule 32A of the said rule. Rule 4 of the 2003 rules lays down the method of recruitment to the post of junior assistant, which says that the said post shall be filled up by way of direct recruitment by the appointing authority from the select list prepared by the school selection committee on the basis of the test and interview. As per Rule 4, Roman 4, the school selection committee shall prepare a select list of candidates containing double the number of the vacancies, and the member secretary shall submit the select list to the appointing authority for appointment. As per Rule 2B, Roman 2, Inspector of Schools is the appointing authority for the post of junior assistant. The appointing authority shall fill up the vacancy in order of merit by following the reservation principle for the select list. And as per the Rule 8.4, my lord, who are the members of the selection committee? That is, President of the Managing Committee is the chairman, Vice Principal, Postgraduate Teacher in case of higher secondary school, or Assistant Headmaster or Senior Most Graduate Teacher in case of high school member. One parent to be nominated by the Managing Committee member, Principal, Headmaster of the school, Member Secretary. Then, my lord, the para 10 may be skipped, my lord. Then para 11. Having regard to the scheme of selection to the post of junior assistant under the 2003 rule, as discussed above, it is quite evident that Deputy Commissioner of the concerned district has no role to play in the selection. He is neither a part of the selection committee nor the appointing authority. Neither has he been assigned by any supervisory role. In such circumstances, interference by the Deputy Commissioner in the selection process for the post of junior assistant in higher secondary school and high school would be beyond the mandate of the 2003 rule. As such, the interference is not contemplated under the state rule. Apart from the affidavit in opposition himself, the more particularly from the, well, that does not kindly skip the same mallet. Then para 13. On due consideration and on a thorough examination of the matter, court is of the considered opinion that withholding of appointments to the post of junior assistant in the two schools is not at all justified on non-existent grounds. The selection process was interfered with by an authority who is not authorized to do so under the law. Having regard to the above, Minister of District Nagaon so and so was directed. And subsequently, my lord, the another order has also passed pursuant to these judgment, my lord. My lord, the next case, WBC number 540/2016, my lord. My lord, come to para 13. In the issue of the Deputy Commissioner, District Magistrate Golpara taking up the proceeding in the matter of selection to the post of junior assistant LD and Joleshwar Girls High School, this court does not find any provision in the Assam Secondary Education Provincial Service Rules 2003. Therefore, the proceedings.
All right.
Yes.
Now tell me, whether the earlier selection was cancelled by
No.
any order?
No, my lord.
No.
No.
After
Earlier selection was that nor withdrawn nor cancelled.
report of the after the executive magistrate, whether any
Nothing has been done. Nothing has been done, and that report has been brought on record by you of this affidavit. And on the basis of the report, nothing adverse order has been passed, neither by the Deputy Commissioner nor by the Inspector of Fiscal. And these advertisement was not cancelled and withdrawn. In fact, my lord, the rules which was subsequently amended, my lord, that has to be prospected. If there is no retrospective effect has been given, my lord, then the earlier process which was initiated pursuant to the earlier rules, that has to be completed and on the basis of the earlier rules, my lord. And to that effect, my lord, I have some judgment of the learned of the Honorable Apex Court, my lord, wherein it has clarified that the subsequent amendment of rules does not taken away the rights, the limited rights of the candidates who have applied and selected as per the earlier rules. And in fact, my lord, in the Act itself, the section 21 is very clear. that the pendency of the selection process which was initiated as per the earlier rules has to be taken into logical conclusion. But kindly take up the judgment of reported in 2008 3 SCC 724, my lord, para 11. Para 11, we have heard learned counsel for the parties and perused the record. Mr. M.R. Kalla, learned senior counsel appearing for the appellant, has strenuously urged that during the pendency of the selection process, the eligibility criteria were changed and the date for submission of the application is in pursuance to the advertisement was extended, and Rule 266 of the rules of so and so came to being on 30/12/1996, whereby it was provided that higher secondary examination shall be the criteria for preparing the merit list. As such, as per the service rule, the selection should have been made on the basis of the higher secondary examination mark and not on the basis of the secondary examination mark. We regret this cannot be accepted. Once the advertisement had been issued on the basis of the circular obtaining at that particular time, the effect would be that the selection process should continue on the basis of the criteria which were laid down, and it cannot be on the basis of the criteria which has been made subsequently. As per the circular which was obtaining in the time when the advertisement was issued on auto, the criteria for selection to the post of teacher of grade 3 was secondary examination, though this was changed during the pendency of the advertisement. Subsequent amendment of the rules, which was prospective, cannot be made retrospective so as to make the selection on the basis of the rules which were subsequently amended. If this was to be done, then the only course open was to recalls the advertisement so and so and to issue fresh advertisement according to the rules which had come into force. Secondly, this was not done, and the error was the authorities made the amendment rules applicable and proceeded with the selection which resulted into litigation, and ultimately the so and so succeeded in that litigation, and it was held that the selection should be made as per the secondary examination mark, the criteria which was prevalent at that time when the advertisement was issued. And then, the next judgment, 1990 Supreme SC 2200, herein also, in paragraph 11, that there is yet another aspect of question where advertisement is issued inviting application for direct recruitment to a category of post, and the advertisement expressly states that the selection shall be made in accordance with the existing rules or government orders, and if it further indicates the extent of reservation in favor of various categories, the selection of candidate in such a case must be made in accordance with the existing rules and government orders. Candidates who apply the undergo written or viva voce stage acquire vested right for being considered for selection in accordance with the terms and conditions contained in the advertisement, unless the advertisement itself indicates a contrary intent. Generally, a candidate has right to be considered in accordance with the terms and conditions set out in the advertisement as his right crystallized on the date of the publication of the advertisement. However, he has no absolute right in the matter. If the recruitment rules are amended retrospectively during the pendency of selection, in that event, selection must held in accordance with the amended rules. Whether the rules have retrospective effect or not primarily depends upon the language of the rule and its construction to ascertain the legislative intent. The legislative intent is ascertained either by express provision or by necessary implication. If the amended rules are not retrospective in nature, the selection must be regulated in accordance with the rules and orders which were in force on the date of advertisement. Determination of this question largely depend on the facts of each case, having regard to the terms and conditions set out in the advertisement and the relevant rule and orders. Here in this case, as per the section 21 of the new act, it has clarified that the selection process which was initiated pursuant to the earlier rules has to be taken into logical conclusion. So, and another is the similar line, the others does better. Yes, yes, so my humble submission before your lordship, since they did not have withdrawn or cancelled the earlier advertisement, and in the subsequent rules has not been amended retrospectively, and the earlier selection process neither been cancelled nor withdrawn, my lord. And my humble submission, and the deputy commissioner, since he has no authority to interfere into the selection process, so the selection process initiated pursuant to the advertisement dated 30/10/2019 has to be taken to logical conclusion. That is my humble submission by setting aside the notice and the impugned letters.
Your my lord, admittedly, my lord, the election process was not progressed further due to there are some anomalies reported to the deputy commissioner, and deputy commissioner conducted an inquiry, and in the inquiry, my lord has already gone through the report of the inquiry. There were it found that he could score only 17 point something marks, whereas in the actual test he could score 70, my lord.
Under what authority?
That is there, my lord. That is there, my lord. That is there. But since a deputy commissioner is a educational head of the district, my lord,
Inquiry can be made such a
that is very difficult, my lord. But
why it is difficult? You explain it. Who had given you the authority to interfere with the
my lord,
whether rule provides so?
there is no provision in the rule as such, my lord.
Then
But as a district head of the district administration, my lord, in fact, the educational as a district administration, my lord, he has the authority to look after the.
no, the authority must be derived from any act or any rule or any executive instruction. What instruction or what?
There is
act
no rule as such, my lord. Admittedly, there is no rule as such, my lord.
nor
So on because of that
then
inquiry, my lord,
without cancelling the earlier process, how can advertise the press advertise for the same?
no, in fact, we have not issued any fresh advertisement.
Then
But subsequently, after these rules come into force, my lord, all the analogous grade 3 and grade 4s are under the direct recruitment commission, my lord. So they have issued the advertisement, my lord, and pursuant to that, my lord, they have selected the candidate and we have allotted the post to the Krishna Madrasa, my lord. So accordingly, the respondent number 7, he was appointed. But subsequently, she resigned from that post, and the post is presently lying vacant.
are you sure?
Yes, my lord, we have filed an affidavit to that effect, my lord. In fact, there is an order from this honorable court to clarify that position. So accordingly, we have filed an affidavit on 27/1/2025.
Page number?
Page number, my lord, in my page 91, my lord, by one Anup Kumar Das.
Paragraph number?
Paragraph T, my lord. That the deponent most respectfully begs to state that state level recruitment commission, in view of ongoing vacancy, published an advertisement dated so and so. Further, the advertisement was contained only tentative vacant post and no school name was thus mentioned in the said advertisement. Accordingly, as per recommendation of the state level recruitment commission, Ubali Datta was appointed as junior assistant in Krishna Higher Secondary School. However, the place of posting of Krishna Higher Secondary School was declared published by the Director of Secondary Education Assam along with 15 other of various provincial high school, higher secondary school under the district of Gwalpara, and not by inspector of school. Whereas due to some personal problem, Ubali Datta Junior Assistant Krishna Higher Secondary School was resigned from her post on 10/5/2024, and thus the post of so-and-so has been lying vacant since then.
Any other
No, Malad.
part are order reserved.
Master, sir.
Right, please, Lord. I refer to order dated 2025. My lord, it is a case of 2022 regarding selection and appointment. My lord, petitioner was selected by DLC, but SLC did not recommend him. His service was not taken. So, my lord, we challenged it in 2022, my lord, 3 years passed. Your lordship now see the order dated 28/2025. Your lordship, government said that they have got instruction and file affidavit in opposition. But till that, they did not.
No affidavit has been filed.
No. No file, Mr. Some Fukon, A. Fukon was there. Nobody is here to represent the government, madam.
After some time,
Yes, madam.
May I please, my lord? My lord, I'm for the respondent number 1 to 4. Lord, we
Yes.
are praying for 4 weeks' time for this matter.
pardon,
We are praying for 4 weeks' time to file our affidavit.
you have not filed your
Not yet, my lord. We have not.
part.
Yunanda.
I'm K. Vishwakarma on behalf of Mr. S.P. Chaudhary. Respondent 1 to 4.
There is a after the vacation.
Lordship, any date
Obliged.
may be given, Lordship.
Obliged.
I'm sorry, my lord. I was in another court in earlier matter, my lord. I pray for 1 week time, my lord. Or
9, item number 9, madam.
at 9, my lord. My lord, as per honorable court direction, my lord, we have filed our ready our affidavit and send for vetting, my lord. And copy not received, my lord. So I pray for 1 week time, next week any date, my lord. To Friday, Monday, Tuesday, Wednesday, any day.
Part time.
My lord, ready and send for waiting, my lord. That may be recorded,
My lord,
my friend's submission.
Order of on
obliged, my lord.
Right. This is regarding selection appointment will be held for while. There is an advertisement will not, the post will not, and I will not applied for the same. But I was not selected. Selected by some other person who is will not outsider. And the CDBO has filed me an affidavit and notice was issued to all Milot and all have been served properly. There is official Milot and official notice has been served properly to all the persons. Yes. Correct. Yes. My submission is that I am within center area, I am to be selected and appointed by us not given. And the person who is in appointed is number 6. He is an outsider And respondent 7 is his sister-in-law, so he selected Millard, made a survey Millard and her name Millard included in the sentence. So he is selected. And CDPO will only file Millard affidavit saying that he or she, another person is appointed, but no document, nothing has been given. An advertisement Millard was made, you must may kindly see, 1/11/2024. I have given an extra Millard, that is an extra 1 Millard, just 15. And before that Millard, that date, there is no document that the respondent is residing within the region Millard that Anganwadi center. Yeah, that is a Millard. Badongdunga Anganwadi center. So, Golf. And I have given Millard in except 2 my government certificate. I read up to class pass 10 9 Millard. And as per this Millard, I have passed my class 10 9. And class 8 is required pass for the post of helper. It is not the worker Millard. I have given my Aadhaar card also Millard.
Are you ready for
Lordship, so far we submitted our affidavit, Lordship, but Lordship, the record is required, Lordship, regarding the survey register, Lordship. It is stated in my affidavit, page 45, Lordship. Page 45, paragraphs 8, Lordship. The primary grievances of the petitioner is that the respondent number 6, who was selected, Lordship, she is not within the she is not she is outsider the Anganwadi center. Now my retaliation is that, Lordship, in paragraphs 8, her name is enlisted in the survey register of Bandonga Tiniali AWC. It means within the survey register. It means she is within the Anganwadi center, but the record is not available with me, Lordship. At the same time, Lordship, second grievances of the petitioner is that she was regular student at the time of selection in class 12 in some Gornagar Senior Secondary School. We received one certificate issued by the principal. It is paragraphs 9 in my affidavit. It is categorically stated, Nong 6 is not a regular student as per the certificate issued by the principal of Gornagar Senior Secondary School, Lords. Therefore, Lordship, this record may be called for, Lords.
My only one submission regarding the school certificate. As per advertisement, you have mentioned regular student cannot apply for the post.
Yes, Lord.
That is their advertisement. And Millard here in annexure 7 page 32 of my petitioner Millard, your lordship may kindly see. This is not a transfer certificate. This is only a letter to the CDPO. How they
something for this survey registered? Register or record?
It is a survey register, Lord. The relevant portion of the survey register wherein the name of the petitioners are enlisted. Name of the respondents, private respondents are enlisted, Lord.
Or
6, Lordship. 6.
8.
6 has been appointed.
6. She was appointed.
Or okay.
Lordship, I'm on behalf of 1 to 5, Lordship.
Order to perusal of the survey register.
Lordship.
Contain the name of number 6.
Lordship.
Of the survey register. Okay, the next after or before vacation?
After vacation, Lord.
After vacation,
On 24th, my lord,
24.
24th. Maybe it can be treated as a part of my lord. Maybe it treated as a part of my lord.
Okay, it's the
Please, Your Lordship, my lord, in 14 and 15, both the cases, two IAs have been filed by us seeking implement as parties in the writ petition. On the last occasion, my lord, the counsel for the respondents, they sought time to file some objection. They have filed an objection, my
I
lord,
filed
but-
the objection, but it's not in the record, my lord. May I serve a copy, my lord? They're in file.
But basically, nothing, as far as I could see, my lord, nothing seriously against our implement in the case. All that they have got to say is against the writ petition. Now, writ petitioner is the main party in the situation, my lord, where we should be added as party of respondent, party in the case or not. They have not, they have no objection.
No, no,
In fact,
regarding
as a matter of
my lord, we have objected, otherwise why will you file the affidavit?
No, I am not on the objection of these state respondents, my lord, because when I am asking for my implement, my lord, it is basically for the writ petitioner to file any objection if they have got any. They don't have any objection. And as a matter of fact, my lord, in similar cases, your lordships had passed orders by which, my lord, the implement was allowed. Your lordship will kindly see this, my lord. This is in similar writ petitions and perhaps the
First of all, lordship, my lord, let the implicants, my lord, who want to be implicated, let them, my lord, place the case, my lord. Why they want to, my lord, get my lord, implicated in the present proceeding? They are students, my lord. What has happened is, my lord, so far as the present writ petitioner is concerned, they have applied for affiliation for running a college, my lord, in Assam Science and Technology University. That particular application is still pending. In between, my lord, without having that affiliation, what the petitioner has done, my lord, they have admitted this, my lord, applicant in different courses, in the Bachelor of Architecture, in, my lord, BTech, and in, my lord, MBA, without their being affiliated. Well, that itself is, my lord, illegal. Otherwise, they should not have, in fact, they should not have played with the career of the students, my lord. Also, will see the conduct of the petitioner. How they can, my lord? Writ petition is pending, their application is pending, my lord, awaiting the affiliation. In between, they have taken the fees, they have admitted the students. Now, thereafter, they inform the applicant that the affiliation is awaited. So that's why they are before the Honorable Court agitating against the state as well as the, my lord, university, along with the petitioner. Yes, my lord. How they are a necessary party in the present proceeding, my lord? If they have any grievance
in the case
against
which
the
I have
college.
placed before your lordship's order in the case which I have placed now, there also the same situation was prevailing and your lordship allowed the students to be made party.
But in that case, though the students after they appeared,
Exam.
appeared in the examination, their examination were not declared.
Yes, my lord,
The
but
result of the examination was not declared. Therefore, they have reached part.
here also, my lord, they have already got the admission now. They have already got the admission and the process in the writ petition which the college has filed, my lord. In the college, in the writ petition, my lord, we are interested in the outcome. Even if we cannot be implemented as petitioners in the case, my lord, we can certainly come as interveners. We can support the cause of the writ petitioner. My lord, there cannot be any impediment in implementing the party as interveners. We can always be there.
Where is your affidavit?
My lord, may I please?
When did you file it?
My lord, today, in the morning, I filed.
Let it come after the next.
Lordship, in the main writ petition, Lordship, my landed.
Yes, by Monday, my lord, or Tuesday, I will
They
file
have
the
not filed
affidavit.
yet affidavit.
Lordship will post it on a hearing day, entire matter can be traced out. Otherwise, my lord, they are waiting affiliation.
Lordship, only one point, Lordship, regarding the no objection of the
Yes,
NOC of the state, Lordship. That point, Lordship, my landed friend has filed their affidavit by Monday, Lordship.
Yes, I will.
file reply.
Lordship will, my lord, post it on a hearing day. Let this particular IAB also there, my lord, will consider entire writ petition.
And in the meantime, my landlord
Yes,
have to file their affidavit, lordship, because the
আপনার convenience
Or
আপনার দিকে
ও convenience দিলে তো মুশকিল। আর 9 তারিখে দিও, 9 তারিখ 9।
health, madam. I'm appearing, yes, madam. I'm appearing for the respondent 1 and 2.
for what? Sophia po?
Please, please.
Still, respondent two.
Please, please. Higher do.
9th পড়িবা নে? 9th পড়িবা?
Affidavit দিব না।
By Monday or Tuesday?
Well, let it be Tuesday, my lord. And lordship will post it on 15 by 18.
18 হবে পরে।
18th, my lord. 18th of September.
Hello, I but
my
provide on 18.
18 9.
18
in the meantime, lordship, my landlord
yes.
said
Affidavit, I will.
they will exchange their 15 also same, lordship.
Same, madam. Different courses. Same.
Different courses, same, lordship.
May I please, your lordship?
Lordship.
Here, my lord, before my learned friend starts, madam, I humbly submit before your lordship. Complete copy is not supplied to us. One annexer is left out. Next number.
They have already filed their affidavit also. Now they are.
That's all right, my lord, but
not
that
supply.
complete copy is
Anyways, I will
necessary.
supply, my lord. But they have already filed their affidavit. And after filing affidavit, now they are saying that complete copy has not been served, my lord.
That is necessary, madam.
Anyways, I will.
Copy of
Annexer 6, my lord. Annexer 6.
Annexer 6. Or 54 or
Gradation list, my lord. Gradation list not supplied to us.
then Madam, you are for
Secondary education.
third. Second. Fourth. Take subset. The petitioner is not party. Annexer number 6. Came along with the copy part. Earlier. And for the
My lord, there is no annexer 6 in the petition itself, my lord. There is no annexer 6 in the petition, my lord. In the petition,
Is it Anjana Shoikia Bora?
my lord.
Anjana Shoikia Bora.
We have annexer up to 5, my lord. Annexer 5.
But
Yes, my
here in the index, my lord, annexer 6, office letter, election commission.
It is their affidavit he is referring, my lord. Annexer 6 of his affidavit, my lord.
My lord, I'm sorry, I'm going, my lord. Actually, that is not supplied.
Just an excuse, my lord. Annexer 6, they are referring from their
2, 6,
affidavit, my lord.
6, 5, 4. Just 1 minute, ma'am. Your lordship, seniority list, annexer 5.
Annexer 5.
Seniority list, annexer 5. Annexer 5, that is not supplied to us.
Officer Bora submitted the day part copy of the 5.
Of the entire petition, I will.
That is seniority list of teachers. And that is very vital document, my lord.
After the Bora part copy of annexer 5.
Lord, earlier date may be
After,
fixed, my
after 1 week, my lord.
After 1 week, my lord. Any take convenience to your. Yes, my lord.
23rd.
Obliged, my lord.
May it please, your lord. Lord, the petitioners, my lord, they were
appointed as junior engineers in PWD roads department, my lord. Then, my lord, during their subsistence of their services, my lord, they acquired, my lord, the requisite qualification, my lord, for getting promoted to assistant engineers. And, my lord, there was one issue, my lord, which was subsequently settled, that the institute from where they acquired the qualification was not AICT approved. And that then, my lord, we approached the honorable court, making AICT a party. And AICT, my lord, they filed their affidavit saying that the institute from where we have done our qualification, my lord, it was AICT approved. And then, my lord, they were promoted to, my lord, the assistant engineer's post, my lord. Now, my lord, that notification,
Lordship,
30, my lord, page
PW Council is in Lakes, your lordship. Lordship, after some time, your lordship.
PW.
Yes, lordship. Another court, your lordship. To some time, your lordship.
Whether it's a 5-year.
I just see and started me to pass over, same in Lakes in another
because
court, your lordship.
the interim, my lord, that prayer for interim needs to be considered
Will be
as
there.
per the last order. Deeply observed. Deeply observed.
May please, Your Lord. Present matter involves lordship prolonged suspension of the petitioner. Lordship. Petitioner was arrested on the charges of corruption, lordship. That is annexed to page 17, lordship, on 10/7/2024.
So you have received instruction in respect of extension of your
Yes, lordship, that is on the 91st day of the, from the date of impugn order, lordship.
in 90 days.
Otherwise, it was as mandated by authority judgment, lordship, that is 90 days, within 90 days.
So these orders were passed in the period of 90 days.
They have exceeded, lordship, and on 91st day, they have reviewed the order.
90?
91st, 91 days,
91.
Yes.
Not in 90.
not within.
Which order was passed beyond 90 days?
That is, lordship,
30.
29th November, lordship, 2024. On the last occasion, they have produced the instruction. Lordship.
Yes. Which order? There are 3 orders.
First order, lordship, 29 November 2024.
Okay.
And the petitioner was placed under
This order was not passed within the period of
90 days. Yes,
So as per authority case, it should be within the period of
90 days.
Lordship, if we exclude the date of suspension, lordship, 30th, if we exclude, then it will come within. Suspension order was passed on 38.
2024, Lord.
So it is, if we exclude that date, lordship, it will be 90 days. It was on 29/11/2024, the first suspension, that order was passed. And second and third is very well within 90 days again, subsequent, 27/2/2025 and 3/6/2025. These 2 dates were within those 90 days interval.
First and second.
So second and third. Second and third.
The first one is
Second and third is
90
within
days.
that 90 days interval. That is there. But 29/11/2024,
That is beyond
if
90
we exclude the date of suspension, then it is 90 days. 29/11. The order was passed on 30.
The date of suspension is
38. 38.
38/2020. So 30.
1 day is left, Lord. September is 30 days.
30 days.
And
And
October is
29 days.
31 days. That is 91 days, Lord.
Lordship.
91.
91 days. Also, otherwise, this is technically the order was passed on the 91st day.
If the first extension order was taken, then
That is there. That is, otherwise, lordship, the department proceeding has already been initiated. It is on the verge of completion, lordship.
Let it go on.
Lordship, lordship.
But you take it into logical construct.
Lordship.
But it's a order to go.
This is 29 days and 30 days. One.
Lordship, may go
and
through the
30.
Where is the suspension order?
page 33, Lord.
30?
33, Annexure 6.
One. And it is 30. September, October, November is 25. Only one day. It was month wise, it is within 3 months. But 90 days is
Sir, is the date of suspension counted or not?
these here. But how did you do it? Yes, yes. Okay. Did it? There is space. There is space. Intimation to the intimation day. Now that 90 days again comes from the date the petitioner was released on bail and intimated to the department. From the date of intimation, it comes the 90 days period. So that date of intimation by the petitioner after release on bail will be considered, will have to be considered.
As part?
And it is even though accused whether it is in the
When the order was supplied,
I'm not talking when the
is 36.
That was indicated on
is 30.
Let me take up the let me take up the original.
Lordship.
The date of arrest. Effect on the date of arrest. Thank you.
Lordship. From the date of arrest.
Paragraph 4 of the suspension order. Paragraph 4 of the suspension order. Paragraph 4 of the suspension order, page 33, Lordship. And standing role of the departmental proceedings, Sri Jivanta Gogoi, senior assistant, is hereby placed under suspension with effect from the date of arrest, that is 10/7/2024, by the Inspector of Police of Soin. And the order was issued on 38/2024.
Now tell me from which date it is to be counted. The date of completion of the order.
Lordship, he was learned by the auditor. He was released on bail on 9/8. The petitioner was expecting a revocation. When there is
Annexure
no
5 bail order.
the intimation to the department. there is no intimation letter by the petitioner to the department as regard his release from the release on bail.
They submitted that it should be counted for the date of publication.
Otherwise,
When
it's not.
the-
That
on
does not-
what basis it is
Not, sir. Otherwise, order from the date of arrest that it is not.
what is the decision of other
Yes, Lordship, that is their Lordship, paragraph 14, Lordship,
paragraph?
14. Lordship. May I read it, Lordship?
When the third sheet was submitted to me.
Third sheet is yet to be submitted,
Third-
Lordship. Is yet to be submitted, Lordship.
When?
The show cause was served upon the petitioner, Lordship.
Well, 2024. The Bora,
Yes, Lordship, Annexure 7, Lordship.
the third sheet.
Doubt charges to also frame, Lordship, beyond the 90 days, Lord. Doubt charges to are also framed beyond the 90 days, Lord.
Yeah,
12 plus 2,
No, when we did the third.
Lordship, I have that instruction, I have to take, Lord.
Otherwise, Lordship will fix after tomorrow. I will get that details also. When was that charge? It was served on him. And all the details, Lord.
Day after tomorrow.
I'm on next Monday or Tuesday. Any day. Give that details. Even I am not having one. Something.
You have not stated in your petition on that you have received the third.
No, Lordship.
Lordship. Lordship, as per that instruction on the last occasion placed before your Lordship, that first order of 29 November 2024, Lordship, second paragraph, whereas 29 November 2024, the Lordship was marked as A, B, and C respectively. Lordship. Second paragraph, there is the in-person was issued to the DA. There was a on 28/11/2024 for submission of draft charge and statement of allegations against leveled against the DM. Even the date is also not up. Lordship, will fix the day after tomorrow. I will.
They take up another two. Lordship,
This
may
is-
take up another three decisions of this honorable court, Lordship, that has been passed beyond the Lordship.
But now cannot say that the certificate was furnished. First out.
Lord.
Take him after.
Okay.
Five.
Lordship, in this case, today I have filed my affidavit, Lordship. Today I have filed my affidavit, Lordship.
It is on the record.
Not on the record, Lordship.
Lordship, is it serial number 19?
Yes, you were not audible.
Regarding
Lordship,
maintainability
Lordship,
of this petition here, Lordship.
It is serial number 19, Lordship. Lordship, am I audible?
Item number 19,
Lordship, am I audible?
slightly.
Lordship, in this matter relates to the invalidating medical board, and this matter was considered by Lordship on 18th July 2025, and Lordship has been pleased to issue notices to all the respondents and granted interim protection to me, Lordship. Thereafter, the case was listed on 22nd of August 25, Lordship, and the Lordship has been pleased to direct, and my learned friend took an objection that since AFT Guwahati is functioning, therefore it should not be entertained by Lordship. Then Lordship directed respondent, my learned friend, to certify that armed force personnel is functioning in Guwahati. And the affidavit my learned friend has sent to me, and it is quite misleading, Lordship. I'm sorry to say that. It is quite misleading. In fact, AFT Guwahati is not functioning. Office is there, but there is no judicial member at present. Since long there is no judicial member, so there is no regular sitting in of AFT Guwahati, Lordship. Occasionally, through video conferencing within one month or 2 months, some meeting is arranged, Lordship. There is absolutely no regular bench in AFT Guwahati, and my learned friend has served the copy to me, which is actually affidavit has been stated by the AOC 19.
That affidavit is not before the court now.
Lordship, the only
Lordship.
thing is that whether AFT is functioning or not, Lordship. I have annexed the notice. He is objecting to that AFT is not functioning, Lordship. Kindly see the notice issued by the IC registrar, Lordship.
That
on
is only
18 to, he said, Lordship, that AFT is not functioning in Guwahati. The only contention is that AFT is here, Lordship, and functioning, Lordship. This is the notice issued by the AFT registrar for issuing of
there is
proceedings.
AFT, Lordship, I too admit, but there is no sitting because of the bond of the judicial members, Lordship. There is no regular sitting at all. And that is why we have approached before the Lordship, and Lordship has considered the issue and already issued the notice, granted protection to me, Lordship, and it is continuing, Lordship. And AFT Guwahati is not, this Guwahati is not functioning repeatedly. I submit, Lordship. My learned friend has given the affidavit. I will file reply to that. On the notice, what they have given, Lordship, just have annexed one of their affidavit which they have served to me. It is for 1 day hearing, and that is video conferencing. Lordship just has annexed one, page 190 they have marked. Just have a notice which my learned friend has annexed.
Lordship, it is of 14/11/2024. I am given 2025 notice, Lordship. That notice of its 2025, Lordship, that AFT is functioning, Lordship.
In the annexure, I have only 12 August 25 notice. 12 August 25, there is one
12
notice.
August 2025, Lordship.
And that is for 1 day hearing, Lordship, and it is through video conferencing.
That is the functioning of the AFT, Lordship. How can we say that you cannot use seat 1 day or 2 days, Lordship? This is the AFT. Only question is whether this court has the jurisdiction when the AFT is functioning, Lord.
There is no question of jurisdiction, Lordship. Vivek said L. Chandra Kumari's clear objection, the Roger Matthew judgment. Lordship, I have quoted in my para Just Lordship have para 11110.
Today, in the council, today we cannot hear the matter. As
Ji.
the affidavit is opposition filed by Mr. S.S. Roy.
Lordship.
And this is not the place on record.
Lordship.
This is the matter in the next week.
Lordship.
Or, sir,
Lordship, meanwhile, the interim order may be extended, Lordship.
Okay.
My,
A.M. Pandey, assistant
yes,
by
yes, K.
IML.
Pandey, yes, K. Pandey, Lordship.
S.K. Pandey, learned counsel for the petitioner, and also heard Sir S.S. Roy, learned CCC. So that Sir Roy said, today morning he has filed the affidavit in opposition, not place on record. According to CCC is provided that the matter of
18th Lordship.
18th
Lordship.
September,
Lordship.
18th of September.
Lordship, in the meantime, interim may be continued
Interim order was ordered and continued.
to the negative. Obliged.
Obliged, Lordship. I'm obliged, Lordship.
On day before we start this matter, the last day, Lordship. So that.
With the update of the cabinet meeting.
Lordship, the instructions are awaited, your lordship, whether it has been placed or not in the cabinet. Here.
Several dates, Lordship, earlier given regarding Lordship, the status and whether it is placed or not.
Because the cabinet has to sit, your lordship, so only on that it'll take
It has declared
lordship.
that
Lordship, that instruction is awaited.
why it was not that
Lordship, lordship. Lordship will give a week's time, your lordship, I'll obtain the instructions. Because on the earlier occasion, some other councillor appeared, your lordship.
next day again
Lordship.
another complaint.
Yes.
Lordship, I'll ensure that within a week that the instruction comes, your lordship. Whether it has been placed or not, your lordship.
This of the
Secondary education.
the board of
Correspondence 6 and 7.
6 and 7 and the board of
Or 5.
number 5.
Right.
The subjects that the inspector awaited. Rest of the after allow
Like the law.
May it please your lordship. Lordship, the matter pertains to appointing the petitioner as the in-charge principal of Sipachar High Secondary HS and NP School, lordship. Lordship, the petitioner was appointed as an assistant teacher in the year 1999 in Sipachar Academy, and lordship, he was promoted to the post of headmaster in the year 2011 in this same school, lordship, Sipachar Academy, lordship. Lordship, on lordship 15th of July 2023, lordship, Sipachar Academy was amalgamated with Sipachar HS and NP School, lordship. Lordship, on the 7th of June 2024, lordship, the petitioner was promoted to the post of vice principal of Sipachar HS and NP School, lordship, by order dated 7 June 2024, lordship. Lordship, where is the respond number 4, lordship? Abdul Latif was appointed as the in-charge principal of Sipachar HS and MP School on 1st of April 2021, lordship. Lordship, coming to the fact that, lordship, coming to rule 2 of lordship, rules of 2018, lordship. Lordship, rule 2I, lordship, graduate teacher, lordship.
Which act?
Lordship, Assam Secondary Education Provincialized Schools, the rules 2018, lordship. Lordship, Assam Secondary Education Provincialized Rules 2018, Lordship. Page number 21, Lordship, of this book, Lordship. Page number 21, Lordship.
Yes.
Definition, Lordship. 2I, Lordship. Graduate teacher means and includes a category of assistant teacher, Lordship.
Yes.
Lordship, respond number 4, Lordship, by order dated 7th of June 2024, Lordship, he was promoted to the post of in charge principal, Lordship. Lordship may be pleased to come to page number 36, Lordship, of the additional affidavit, Lordship. Filed by the petitioner, Lordship.
Upright.
Page number 36, annexure 1, Lordship, of the additional affidavit, Lordship. Order dated 26 March 2021, Lordship. Until further order, Abdul Latif, MA, B.Ed, Assistant Teacher of Sipajar HS and MP School, District Dorong, is hereby allowed to hold the charge of principal in charge of the same school, along with financial power to draw and disperse the salary, etc., of the staff of the school, in addition to his normal duties as assistant teacher under FR 49, while Muhammad Rafiquddin Ahmed, principal, will be retiring on 31st March 2021, Lordship. Lordship, from this order, Lordship, we can see that respondent number 4, Mr. Abdul Latif, was designated as a principal in charge, Lordship, not as a principal, in charge principal, and along with financial powers, that is the duties of the in charge principal, along in addition to his normal duties as assistant teacher, Lordship. Being an assistant teacher, Lordship, he falls under the category of graduate teacher under Rule 2I of the 2018 rules, Lordship. His cadres still remain as great, Lordship, as a graduate teacher, Lordship. He'll be performing the duties of a principal, being by the virtue of in charge principal, but his class, Lordship, still remains as a graduate teacher, being the assistant teacher, Lordship. Lordship, coming to Rule 3, Lordship, of the same rules, Lordship. 3, page number 23, Lordship. Classes and cadres, Lordship. Lordship, classes and cadres, Rule 3. The service in provincialized schools shall consist of teaching and non-teaching staff as in Schedule 3. The teaching staff shall consist of the following classes and cadres. Each one of those consisting a distinct and separate cadre as on the commencement of these rules. Namely, Class 1, it includes principal. Class 2, vice principal. Coming to Class 3, Lordship, it includes 3B2, graduate teacher, Lordship. Lordship, it can be discernible that vice principal falls under Class 2, whereas graduate teacher, which includes assistant teacher, falls under Class 3, Lordship. Respondent 4, Lordship, being the assistant teacher, being a graduate teacher, falls under the cadre of Class 3, whereas the petitioner, who is presently the vice principal of the said school, Lordship, by virtue of his position, Lordship, he lies under cadre 2, Lordship, Class 2, Lordship. He's a cadre above than that of the respondent 4, Lordship. And Lordship, coming to Rule, Lordship, 12, Lordship, at page number 32, Lordship.
Yes.
Lordship, recruitment to the post of principal and procedure thereof. Clause 1. The post of the principal is in provincialized higher secondary schools shall be filled up by direct recruitment. from the candidates amongst the cadre of postgraduate teachers of senior secondary and higher secondary schools and graduate teachers of higher secondary schools as per procedure. Lordship, it can be discernible that the post of principal can be filled up only through direct recruitment, Lordship, not through promotion, Lordship. In the present case, Lordship, we are Lordship, the respondent number 4, Lordship, he's an in-charge principal, Lordship. He's not the principal, Lordship. And secondly, Lordship, there's no post, there's no rule for an in-charge principal, Lordship. There's a distinction between principal and the in-charge principal, Lordship. And coming to Lordship, Rule 12.5.1, Lordship, 5.7, Lordship, no appointment in any manner shall be made an authority except in accordance with procedure prescribed above, Lordship. Lordship, the manner in which he was appointed, Lordship, as the in-charge principal, Lordship, shall not be, will not be deemed to make him a principal, Lordship. He'll still remain as an in-charge principal, performing the duties of a principal, but his cadre, his class and duty still remains as that of an assistant teacher, which falls under class 3 assistant teacher, Lordship. Lordship, from the above, Lordship, it can be discernible that a person who falls in cadre 3 cannot supersede a person who is in class 2 or class 3 to become the in-charge principal, Lordship.
Get the notice of that.
Lordship. Yes, Lordship. Lordship, please to come to page number 29, Lordship. Lordship of the Lordship writ petition, Lordship. Page 29, Lordship. Relevant, Lordship. Type copy of the relevant portion, Lordship. Lordship, Nobokanta Bora, that is a petitioner who was the head, whose designation is of a headmaster, Lordship. And Abdul Latif, who is a respondent number 4, Lordship. His designation is assistant teacher, a graduate teacher, Lordship.
Class 2.
Yes, Lordship, class 2. He was the headmaster, Lordship, as per order dated, Lordship. As per order dated 7 June 2024, Lordship, he has become the vice principal, Lordship. Lordship, the order is at page number, Lordship, page number 28, Lordship, the previous page, Lordship, Annexure 6.
The vice principal of the other master.
Yes, Lordship.
Secondary part.
Yes, all right.
Lordship, your pagination is different, your lordship, it seems. It must be 54, your lordship.
our affidavit, Your Lordship, page
Number?
54. 37. I think it's 37, but tomorrow, okay, 50. Lordship, I'm sorry, Your Lordship, it's page 37, Your Lordship. Page 37. Respondent number 2, Your Lordship. And the main paragraph where we have stated why the petitioner was not appointed as principal in charge, Your Lordship, is at paragraph 9, Your Lordship. Because the school was amalgamated, Your Lordship, and school was amalgamated in the year 2024, and the petitioner was made vice principal in the same year, Your Lordship, on the same year. And paragraph 9 we have stated, Your Lordship, is because of the rule 12.3.3, Your Lordship. 12, rule 12 is at page, Your Lordship, page 32, Your Lordship. Page 32, Your Lordship, subclause 3, Your Lordship. 3.3. The candidate must have rendered at least 5 years of service as principal in any of the provincialized high secondary schools.
And
Lordship, he was in, yes, Your Lordship, he was in charge when the school was not amalgamated. He was in charge principal from that period itself, Your Lordship. And here, Your Lordship, this is a temporary arrangement, Your Lordship.
But after amalgam,
Yes, Your Lordship. But in Jagannath Pegu,
plus of the higher.
yes, Your Lordship. Lordship, I have seen that. I have seen that. Yes, Your Lordship. He's senior, but Your Lordship, in Jagannath Pegu, Your Lordship, in that case, it has been stated that the in charge principal, whether in charge principal or headmaster, he should have the required qualifications, Your Lordship. And here, Your Lordship, in Rule 12, Your Lordship, the required qualifications has not, he has not fulfilled that required qualification, Your Lordship.
How
No, so even, in fact, even he does not fulfill, Your Lordship. Lordship, here in Rule 12, Your Lordship, it doesn't speak of seniority, Your Lordship, as because in headmaster, if Your Lordship sees Rule 14, Your Lordship, here the provision for seniority is given, but for appointment as principal, there is no mention of seniority, Your Lordship. Here it is made to direct recruitment, Your Lordship. Advertisement is given. Interview is held, Your Lordship. And in fact, Your Lordship, it is an ad hoc appointment, Your Lordship. It's a temporary arrangement, Your Lordship. Till Lordship, 14. Lordship for vice principal. He is the vice principal, Your Lordship. It's a regular appointment, Your Lordship. But he was appointed as a vice principal only in the year 2024. And for principal, Your Lordship, he has to have 5 years of experience, 5 years of service. Lordship, it is in charge. His prayer is for in charge principal, Your Lordship.
Otherwise, it's that
Lordship, this
for private respondent.
First of all, my lord, that graduation list, my lord, is wrongly, my lord, actually, National Court is the, my lord, senior most. He was appointed in my lord in 1990, and my lord, page 29 of the repetition, my lord.
Yes.
My lord, in first one, Navakanto, Lord, date of appointment, my lord, 1999. And Abdul Latif in 1990. The thing is that, my lord, we are that repetitioner, my lord, from another school. My lord, that was that graduation list, my lord, wrongly typed out. I will take information that was this, my lord, drill list was this wrongly, my lord. There is a, my lord, mistake, my lord. There. Another thing is that, my lord, case is that first I have filed my affidavit in opposition. My lord, the as per my lord, Shiksha, my lord, Kshetro, my lord, that is the scheme, under scheme, the schools are, he was serving in a high school and I was serving in a higher secondary school. In a higher secondary school, at that time I was assistant teacher. And after the retirement of the, my lord, earlier principal, my lord, I was arranged as a in-charge principal. That was, my lord, my learned friend annexed in the additional affidavit in 2021, 26/3/21. Already my learned friend, my lord, submitted. And thereafter, my lord, if lordship come to the, my lord, Shiksha Kshetro, which was, my lord, page 49 of my affidavit in opposition, my lord. Here, as per, my lord, para 3, column 8, my lord. Page 51, my lord. Page 51, my lord, para 8. In the event of highest school is junior college, the principal of the junior college shall continue after amalgamation. The post of headmaster of high school shall be redesignated as vice principal with same pay scale, whatever they are doing, and the post shall be held by the existing headmaster of the high school without requiring the qualification for the post of vice principal. However, after cessation of the service, such vice principal,
Which paragraph you were reading?
my lord, my affidavit in opposition, page 51, my lord, para 8. So school was amalgamated. That is the scheme, my lord. Without challenging that scheme, at first they have to challenge that scheme, my lord. Here that at the school was amalgamated, and my school is base school, and the repetitioner school is the merger school, and here it is, my lord, clearly in the scheme mentioned, if the highest school is higher secondary school, in the event of highest school is junior college, the principal of the junior college shall be continued after amalgamation. The post of headmaster of a high school shall be redesignated as vice principal. So, my lord, he was headmaster, and after amalgamation, the writ petitioner become the, my lord, assistant assistant teacher, my lord. And till date, no advertisement of the principalship, no appointment of principalship, and then that is why that interest principal is given, my lord. Another
But even the vice principal or the
my lord, I was appointed as a interest principal much before, my lord, much before the amalgamation. He was in another school, and I was in another school, the present school. So, my lord, when no other any incumbent, my lord, challenged my order, after coming from that school, he is challenging my legality and validity. But as per scheme, I have been holding that post, my lord. Another that the petitioner ought to have challenged this Shiksha Khetra scheme. And another thing is that, my lord, in writ petition, my lord, page 28, writ petition.
Yes.
My lord, here, earlier the petitioner, my lord, submitted that representation, and on the basis of that, my lord, this order was passed. And writ petitioner, that was not challenged before this court, my lord. It is also not challenged. Another thing is that, my lord, in the next previous page, my lord, page 27, my lord, page 26, NSR 5. Here, page 27, my lord, paragraph 7 and 8. 7, my lord. If the highest level school is a high school, higher secondary school, senior secondary school, my lord, 27 page, writ petition.
Yes.
Page 27, the paras 7, my lord, 7 and 8. 7, if the highest level school is a high school or higher secondary school or secondary school, senior secondary school, the headmaster or the principal of the highest level school shall continue after amalgamation. So before amalgamation, I have been holding the charge of in-charge principal. Next, my lord. The post of headmaster of the ME school, high school, shall be redesignated as assistant headmaster or vice principal with the same pay scale, whatever they are drawing as headmaster of the ME high school. Next, paragraph 8, my lord. The senior most principal headmaster shall be the principal headmaster of the school after the merger. If the date of joining happen to be the same, then the seniority in age shall be taken into consideration of the seniority. So I was appointed much before them, about 9 years before him, my lord. He was appointed in 99 and I was appointed in 1990, my lord. As per, my lord, that gradation leave. The other principal headmaster shall be the ex officio principal headmaster with the post personal to him, and she shall continue to get his pay in the existing. So, my lord, writ petitioner is to challenge this order also, or Shiksha Khetra also, my lord. And another thing is that, my lord, which was earlier shown, my lord, that order he filed a representation.
Where is the document to show that earlier he was appointed as third headmaster of that?
My lord,
Where is the document to show that earlier he have been appointed as the third headmaster of that?
my lord, that writ petition, my lord, is
Lordship, Lordship, he was never appointed as the in-charge headmaster lordship. He was the headmaster lordship, not an in-charge lordship. He was the headmaster lordship.
he was headmaster of another school. Lordship. And I was in
He has submitted that 2020 for insert that third of that.
my lord. My lord,
Where is that?
that is in my lord. In interest principle, my lord.
My affidavit, your lordship, is that
Is what?
8, your lordship, 50, your lordship. Annexure 3, your lordship. My affidavit starts from your lordship 37.
So, your object of is the year 2021.
My
And the amalgam is the year
23 lordship.
2024.
yes.
23. 15th of July 23, page 26. 15 July 2023. Page 26 of the report.
This order, paper 28.
Yes, lordship.
Annexure 6. That's not
Lordship? No, lordship, lordship, we are not, lordship, we are not challenging order, lordship. We are accepting the fact that he's presently the vice principal, lordship. Lordship, we are challenging the act that, lordship, a person who is of class 3 cannot supersede a person who is of class 2, lordship, to be the in charge principal, lordship. Lordship, we are not challenging this order, lordship.
he has already been hooked up in the year 2020.
Yes, lordship, before amalgamation, lordship. Because after amalgamation, lordship, the situation changes, lordship. Before amalgamation, he may be the senior most teacher, he may be appointed the in charge principal, lordship. But after amalgamation,
As per page number 29,
yes, lordship.
the private judgment, he was appointed.
Lordship, Lordship, may you please come to
And
page, the
another-
next page, Lordship.
In that case, my
Lordship,
lord,
I did not disturb him, Lordship. Lordship, the next page, Lordship, page number 29, Lordship. The actual one, Lordship, not the type one. Lordship, maybe please to come to the last part. Signature and seal, principal in charge, departure, HS and MP school, Lordship. This gradation list has been prepared by the respondent number 4, Lordship. It is not me who has made a different gradation list, Lordship. It is, and Lordship,
This, appointed in 1999.
yes, Lordship.
Appointed in the year 1990.
Yes, Lordship. Lordship, appointment date may vary, but Lordship, the post of headmaster, the one he has become the headmaster, Lordship, he falls under class 2, Lordship. And being the assistant teacher, he falls under class 3, Lordship, a graduate teacher, Lordship. Lordship, we are not denying the fact that he was appointed in the year 1990 and I was appointed in the year 1999, Lordship. Lordship, my humble submission is that, Lordship, being a headmaster who was promoted to the post of vice principal, Lordship, he falls under the category of class 2, and the in charge principal, responsible for, Lordship, who is deemed to be the in charge principal, Lordship, with the duties of a principal, Lordship, but his post still remains as a graduate teacher, assistant teacher. He falls under the class 3, Lordship. A class 3 person cannot supersede supersede a person who is in class 2, Lordship. And coming to the fact that, Lordship, Lordship, if the tenure of a teacher is counted, Lordship, it has to be counted throughout, Lordship. And Lordship, only after amalgamation, Lordship, it is true that the respondent number 2 had been appointed as the in charge principal in the year 2021, Lordship. That was before amalgamation, Lordship. But in the year 2003, Lordship, amalgamation had taken place, Lordship. Then the situation has arisen, Lordship, that a person who is of class 2 has been superseded by a person who is of class 3, Lordship. Lordship, which is against service law jurisprudence, Lordship. And Lordship, coming to the submissions made by my respected Lordship, friend Lordship, respondent number 4, Lordship. Lordship, page number 27, Lordship, clause 7 and 8, Lordship. Lordship, these two clauses are applicable in cases of principal of a higher secondary school and principal of an academy or a secondary school, Lordship. But in our present case, this is not for the post of principal, Lordship. This is for the post of in charge principal, Lordship. And both of them are at different cadres, Lordship. If two equals are to be have to be considered, Lordship, then a principal of the higher secondary school has to be made the principal, and the headmaster or the principal of the secondary school or the academy will be appointed as the Lordship. Will not be appointed as the principal, Lordship. He'll be appointed as a vice principal, Lordship. But in this case, Lordship, it is the respondent number 4 is the in charge principal, Lordship. This clause is not applicable in the present case, Lordship. And Lordship, clause 8, Lordship, we are not, Lordship, being the headmaster of a secondary school, Lordship, he has been promoted to the post of vice principal. Lordship, we are okay with it, Lordship. But we are claiming, Lordship, there has been an arbitrary, Lordship, discrimination in the sense that, yes, Lordship, class.
and another thing is that, my lord, in the
Clause 9, clause 7, 1 the OF dated 8/20/21. Is the part of the record? OF?
Lordship,
OF dated 3/8/2021. Is it part of the record?
memorandum, my lord. Office memorandum.
Okay. I have annexed to your lord. We have annexed, yes, sir.
Yes, sir.
Page 42, your lordship.
Three.
Office memorandum, my lord, affidavit opposition, my lord, my page number 49.
While passing order dated 7/6/2024. Valid on 9 of the poem dated 3/8/2024. Yes, have you gone from
Yes, Lordship. Lordship, in this clause 9, Lordship, in clause 9, Lordship, Lordship, it has been stated in the event of highest level school is being a senior secondary school or a higher secondary school, the principal of the senior secondary / higher secondary school shall continue after amalgamation, Lordship. Lordship, in case of principal, Lordship, we are very clear with the fact that, Lordship, respondent number 4 is not the principal, Lordship. He's the in charge principal doing the duties of a principal, being a graduate teacher. And Lordship, coming to the order, Lordship, of his appointment of order, Lordship, as the Lordship, as the in charge principal, that Lordship, he's allowed to hold the charge of principal in charge of the same school along with financial power to draw and disperse the salary of the staff of a school. That means he's the principal in charge with duties of a principal in addition to his normal duties as an assistant teacher under FR 49C. Lordship, coming to FRSR 49C, Lordship, FRSR 49C, Lordship, it is stated as no additional pay shall be admissible to a government servant who is direct. So, Lordship, his class, Lordship, Kedler still remains as a graduate teacher, Lordship. He still remains as an assistant teacher with the Lordship. We wouldn't have, Lordship, filed this petition if it had been the principal, Lordship. Being an in charge principal who is a graduate teacher, Lordship, cannot.
Fair.
Yes, Lordship.
Was directed by the director by this order 7/34. Citing this provision 7/9.
Lordship, we have not challenged his order because from this order it is discernible that Lordship,
if not prepared on this,
Lordship, we have not challenged his order because from this order, Lordship, it has been discernible that the petitioner is a vice principal. Being the vice principal, he falls under the category class 2, Lordship. If he challenges orders,
on this point of whether this provision has rightly been applied by the director in the order dated 7 or not.
Lordship,
Fact.
Lordship, 7/6/2024. Lordship,
1, 2, and 3. 1, 2, and 3.
M. Hussain, madam.
Or
4.
Third in part is the
Lordship, I have some difficulty on 11, Lordship. Lordship, can it be 16th, Lordship?
only on hearing.
Yes, Lordship. 16, Lordship, just Tuesday.
Yeah.
May please, your lordship.
Yeah.
We have filed an IA, my lord. I think additional solicitor general is also appearing. I have seen the screen, yes.
Yeah.
So,
Lordships, I'm appearing in this matter. Your lordship will recollect that this was heard at Itanagar by my lords, my lord. The preliminary issue in the appeal, my lord, I had made by submission before your lordships, and your lordship were pleased to reserve the order on that part. Now, my lord, so far as the grant of interim order in the main appeal, which was passed to us, was to deposit 50% of the amount. Now, we preferred an SLP before the Honorable Supreme Court against that order to reduce that amount. And the Honorable Supreme Court initially entertained the SLP. Now, if your lordship will see, my learned friend has filed an application before your lordships, my lord. My lord, this was heard on 27/6/2025 by Honorable Justice K.V. Vishwanathan and Honorable Justice Koteshwar Singh. and it is said that we have heard so and so, there shall be stay of operation of the impugned order on the condition that the petitioners as undertaken by them will deposit 10% of the enhanced amount in the registry of the High Court within 4 weeks from today. On such deposits, amount shall be kept in a short-term fixed deposit. There shall be stay of the order of the reference court dated 19/10/2024. Now, my lord, in pursuant to this order passed by the Honorable, so interim order passed by the Honorable Supreme Court, now, my lord, on 21st July itself, we deposited that amount of 10%, my lord, as directed by this Honorable Supreme Court, and a sum of rupees 41 crore 88 lakh 24,706 was deposited, my lord, before in the High Court in the name of by a check in the name of Joint Registrar cum DDO, Guwahati High Court, Itanagar, permanent bench, my lord. So, my lord, to that extent, the amount has been deposited in compliance to the order of Supreme Court. Now, my lord, subsequently, the matter came again before the Honorable Supreme Court on the fixed date, my lords, that is on 18/8/25. Now, on 18/8/25, the Honorable Supreme Court, my lord, dismissed the SLP, my lord, for the reason that one date was missed to be mentioned, that on 5th, actually the filing of SLP process was initiated prior to 5th June. So, but the SLP could be filed subsequently after fulfilling all the paraphernalias on 21st June, my lord. So, my lord, that date was missed. So, on that account, the Honorable Supreme Court dismissed the SLP and said that you make a plea before the Honorable High Court for grant of extension of time to deposit the remaining 40% amount. Now, my lord, to that effect, we have made an application before your lordships for granting, my lords, 1 month time, the process for sanction of the amount, my lord, because it will amount to near about 175 crores, my lord. So that amount, my lord, sanction is to be taken, my lord. That amount will come from the Consolidated Fund of India, my lord, through Ministry of Defence, my lord. So, my lord, that is in the process. So, meanwhile, we have made an application for extension of time for deposit of 40% of the decretal amount, my lord. The lordship will see our application. After stating things, my lord, we have in paragraph, my lord, 9 at page 33 of our petition, your lordship will find that the applicants most respectfully submit that they are in the process of complying with the order dated 12/3/2025 passed by this honorable court in IN number 231 of 2024 in LA appeal number 1 of 24. However, the applicants require some additional time to complete the requisite formalities for depositing the remaining 40% of the decretal amount. It is therefore prayed that this honorable court may be pleased to extend the time for making such deposit by a further period of 1 month. Then, my lords, it is pertinent to mention here that earlier the Union of India had approached this honorable court seeking an extension of 30 days time to deposit 50% of the decretal amount before the registry of this honorable court as per the order dated 12/3/25, which was allowed by my lords, my lord, in terms of section 148 of the CPC. But thereafter, that the order directing to deposit 50% was stayed, my lord. And then finally, my lord, it continued, the stay continued till 18/8, my lord, when the SLP came to be dismissed, my lord. So therefore, my lord, we filed an application before my lords, my lord, for granting extension of time by 1 month for arranging the money and depositing it in the High Court, my lord. That is precisely our petition today, my lords. Now, I find, my lord, a reply has been sought to be made by my learned friend, my lord, opposing it, my lord. So, my lord, my prayer is that in view of the fact that our SLP has been dismissed with respect to the interim order for deposit of 50%, my lord, we had said that instead of 50%, as we have undertaken before the Honorable High Court, allow us to deposit 10%. Initially, court allowed us to deposit 10%, but subsequently court said, no, it is being dismissed. That means you deposit the balance 40% amount before the Honorable High Court. So, my lords, we have made this petition, my lord, before your lordships. to allow us 1 month time to deposit the amount, my lord. That is what our petition is before my lords, my lord. And I seek, my lord, 1 month's time for this purpose.
Prior to that, I take only 1 minute, my lord, date wise. On 12/3/2025, this honorable court directed to pay 50% of the enhanced amount. Then after that, my lord, what happened? Then the matter was, SLP was filed before the honorable Supreme Court. Then Supreme Court, my lord, initially on 21/7/2025, asked to deposit 10%. That 10% has already been deposited. Subsequently, my SLP was dismissed on 18/08/2025. And now the original order by this honorable court, 12/3/2025 survives. So we seek 1 month time to make payment of the rest of the 40%. Well, that is the prayer before your lordship.
My lord, in my humble understanding, this application was an unnecessary application. And my apologies for filing an unnecessary reply also to the same. Firstly, my lord, the Supreme Court did not say, as I see from the order, that you approach the High Court for deposit. Rather, the Supreme Court says that it was incumbent on the Union of India to be completely honest and forthright in approaching this court for relief by way of a petition filed under 136 Constitution of India. So SLP was accordingly dismissed. Now, my lord, the question is that lordship had already extended the time once under provisions of section 148. If lordship sees section 148, section 148 says that the maximum time that can be extended is 30 days. So that extended period stood expired on 12th of July 2025. Now, thereafter, my lord, it is up to them to deposit or not to deposit. The peril is on them, my lord. Under what provision lordship would extend as of now?
Lord,
And
my
anyways,
learned
from
friend
the
is
order,
saying,
date of order, my lord, of 18, another 16, 17 days have already gone by from 18th of August.
my lord, your lordship will
That is how
consider
it stands, my lord.
148, my lord, does not prohibit the court. It, my lord, at a time only 1 month can be granted, my lord. But here, in the meantime, something happened, my lord, that was the stay of that order, my lord. Therefore, 148 does not ties the hand of the court in granting time, my lord. Only if it says that it cannot exceed at a time 1 month, my lord. Therefore, my lord, it does not, my lord, in any way prohibit the court in passing the order granting extension of 1 month.
That is not the language of 148, my lord. But then still, I leave it to your lordship because it's entirely up to your lordship. Deposit, anyways, is a discretionary relief and step that is taken by the court. I leave it to the court. But then, as far as 148 is concerned, it is the maximum time that can be granted. That has gone by. It is up to them. The peril is on them, my lord, either to face execution or contempt if we initiate. Otherwise, there is no execution also pending as of now. So whatever appropriate time they take, my lord, let them deposit.
Mr. Sundar, can you complete the process within 30 days?
My lord, the process is on, my lord. Only thing is that the amount is very big, my lord. So therefore, my lord, it goes to the at the
Union
top.
of India, 100 crore is not a bigger amount.
No, not 100 crore, my lord. It is 175 crore at time is to be paid, my lord. So many explanations is to be made, my lord, by the officials, my lord, different channels, my lord. Finally, the file goes up to the highest level, my lords. So therefore, it takes some time, my lords. The lordship knows in the procedure of the government, it takes time. So only for that purpose, my lord, already the process is on. We have already, my lord, initiated the process. The file is moving, my lord. So in case it is in the order, it is recorded, then by that within the time frame, the money will be deposited before your lordship in the court.
In fact, Mr. Sundar, we have directed the registry of Itanagar banks to list the matter today for delivery of the judgment. Judgment is ready. But because of this IA, we have directed them to list the matter on Monday, next Monday.
Lordships.
For delivery of judgment.
Lordships.
Because lordship will probably call for the records.
I will be seeking
And that had
one.
already come, as I inquired from the Itanagar bank.
Yes.
Payment records on 28/7 lordship will call for.
Heard Mr. T. Sundar?
SD Sanjay, my lord.
SD Sanjay, learned
Additional
Solicitor General.
assisted by Mr. Vaizoy, learned senior subject counsel. Then Mr. B. Patok, learned from the respondent. When look at the application, the applicant, Union of India has right for time to deposit 40% of the digital amount. Right for 1 month time to deposit the balance 40% of the digital amount. Mr. Sanjay submits that against the order with that 12/3/2025. The Union of India has preferred what SLP before the Supreme Court. And the Supreme Court has directed to deposit. What was the amount? 60%.
No, 40%, madam. 10% was paid. 10% was directed, my lord, on 21/7/2025.
What is, where is that order?
That order page 70, my lord.
By the interim order dated, my lords,
Page 70.
27th June, my lord,
68
2025.
probably. Yes,
27th
68.
June.
Oh, 68, madam, yes. Paragraph number 3, my lord. Will deposit 10% of the enhanced amount into registry in the High Court within the 4 weeks from today. Paragraph 3.
Order dated
27th June, my lord.
27th June 2025.
They have deposited 10% of the enhanced amount before the registry of this High Court. Registry of this High Court, and subsequently, the SLP came to be dismissed by order dated
18/8/2025.
Then, as such, Mr. Sanjay submits that the Union of India may be allowed 1 month time to deposit the rest of the amount. Rest of the
Rest of that is 40%, my lord, of the decretal amount.
40% of the amount.
My lord,
B. Pathak, learned counsel for the respondent of the department submits that this court has already done sufficient opportunity to deposit the amount. Then, under section 148 of the Code of Civil Procedure, this court is not entitled to grant further time to deposit the balance of the. However, taking note of the submission of learned counsel for both the parties, and also considering the facts and circumstances of the report, the applicant herein is granted 1 month time to deposit the amount before the registry of its court. In terms of this IAS disposal.
Lordships, the delivery of judgment will be in the next week,
Monday.
or next Monday.
Monday at 2 p.m.
Oh, like 1 month from the Supreme Court's order or from today's order?
Today.
Because already 2 weeks have already gone by from the Supreme Court order.
It will be, my lord, on the preliminary issue, my lord, na?
Okay.
Obliged, my lord. Deeply obliged, my lord.
Grateful, Lord, grateful, deeply grateful.
That please the lordship. My lord, by this writ petition, the petitioner is challenging the order of penalty of compulsory retirement from service. Lordship may come to page 28 of the writ petition. It is the charge sheet. Page 28. You have been charge number 1. You have been alleged for not depositing customers' money on their accounts on the date of receipt
of the deposits on them on various dates while discharging your duty at the cash counter and thereby misappropriating a sum of rupees such and such as per the list enclosed. If your lordship looks at the list, the charge sheet is dated 3/3/2022. The allegation is that he had received money from the depositors on sometime in 2018, 19, 20, 21. And the charge number 2 is after the matter of misappropriation of cash was highlighted, you have committed fraudulently activity by crediting money in 105 number of accounts on 10/11/21 and 18/11/21. So basically the charge is you received deposits from the account holders in the year 2018, 19, 20 and 21 on certain dates, but you have not deposited the money in the account. And when the entire matter was highlighted, you deposited sometime in 2021. Now, what is the reply on the stand taken? Lordship, we will have a look at the reply, which starts from page 34. Reply of the writ petitioner employee. At the outset, I would like to state that the transactions referred to in the letter under
You are referring to page number?
34 is the reply to the article of charges 1/4/2022.
Yes.
Pertains to the period 2018 to 19, which is almost 3 years now, and as such, it is very difficult to recollect anything which is sold. However, as far as my memory goes, it is very clear that I did not do any such act of misappropriation of customers' money by not depositing in the respective accounts. It was relevant to state and point out herein that in respect of any cash deposit in the branch in a given day, a scroll number is provided to the customer in the deposit slip by entering in a register the details of the name of the customer, account number, type of account, and the amount to be deposited. Thereafter, the deposit slip is produced by the customer in the cash counter for depositing the money, and the counterfoil of the deposit slip is handed over to the customer, duly sealed and signed by the receiving cashier. After the end of the transaction hours in the branch, a total cash received from the customers in different accounts are tallied with the scroll register, and if there is any difference or shortfall in the cash, the same can be easily detected, as there would be difference in the cash received and the money sought to be deposited as per the scroll register. In the present case, nothing was detected all these years, and the supervising officers and the branch manager at no point of time had raised any question or issue in respect of any shortfall of cash received in the branch. The functioning of the branch was smooth without any complaint from any quarter. It will not be out of place to point out herein that the customers, account holders of the bank would have definitely lodged complaint against me for not depositing the money in the respective accounts timely after receiving the cash from them, as they would have come to know immediately about the fact of not depositing money in their account from the system generated alert, which are communicated to the account holders in respect of every transaction in the account. The customers had definitely received alert of deposit of money in their account, and on being satisfied, they did not raise any objection. And as such, there was no occasion of delay on my part in depositing the cash amounts received from the customers. Had there been any delay in depositing the cash received in the account of the customers and or for not depositing the received cash, the customer would have immediately lodged complaint in the bank. Surprisingly, not a single complaint has been received by the bank so far, as evident from the reading of the charge referred above. Thus, in the absence of any complaint of the customers, holders, account holders against me, the allegation leveled against me falls flat on the face of the record. It is further stated herein that a reading of the list would go to show that there were some deposits of considerable huge amounts by the customers in different accounts, and it is highly improbable that the account holder would not verify the respective accounts and remain a mute spectator for a considerable long period of time without raising any objection regarding non-deposit of money in their account. As there was no delay on my part in depositing the money received from the account holder, there cannot be any question of depositing the money on any future date. Charge number 2, it is stated that no complaint has been received in the branch against me till date as evident from the charge sheet, and as such it is not clear as to how, who and how the alleged non-deposit of money in the customer's account got highlighted. In the absence of reflection of any such fact in the charge sheet, the foundation of the allegation is vague and baseless. It is further stated that no opinion of expert has been called for in respect of the writings of the deposit slips, and as such, the allegation of writing of deposit slips by me is not correct and the same is denied. As there was no delay on my part in depositing the cash received from the customers, there cannot be any question of depositing the money on any subsequent dates. The allegation is totally baseless and unfounded. Moreover, the customers have not complained against me, nor did they raise any claim of loss of interest on their deposit, and as such, the allegation of misappropriation level against me is legally fragile and cannot meet the scrutiny of law. That apart, the relation between the customer and the bank is that of a creditor and a borrower, for which the allegation of breach of trust against me is legally unfounded. The reading of the charge will clearly reflect that no loss is caused to the bank, and as such, allegation of misappropriation is baseless. Now, I'll take your lordship to the inquiry proceeding. This is the inquiry proceeding, my lord. Only the vouchers, cash vouchers, were placed before the inquiry officer. The scroll register was not produced. Even the accounts of the account holders where the money is alleged not to be deposited is not placed. Lordship will have at the inquiry proceeding. Now, what are the exhibits? If your lordship comes to page 1, the fourth one, the following documents are taken on record for the inquiry and marked as ME1, the charge sheet, ME2, reply, ME3, inquiry order of so-and-so, ME4, letter of preliminary inquiry. Now, he was asked, have you read and understood the charges? Do you plead guilty of the charges leveled against you? He said no. Then your lordship will come to page number 4. Only one witness was examined, the branch manager, who was not the branch manager at that point of time when in 2018, 19, 20. Now, MW1, showing exhibit MERs, please identify these documents. These are the documents of deposit, receipt, vouchers on various days, which are reportedly accepted by the employee from various customers while discharging his duties. Now, exhibit MEX2, please identify these documents. These are the vouchers. Who has deposited the money? So and so. Who has received the money? Have you received any written complaint in the matter? This is very important. This is the presenting officer asking the management witness, have you received any complaint in this matter? Answer is no. Have you received any verbal complaint in this matter? He said yes. Then an objection was raised by the defense assistant. He said, I have an objection, and the inquiry officer held objection is sustained. The inquiry will proceed based on management exhibit 1. That is, that's charge sheet, where no complaint is referred. So one thing is clear, that there was no complaint from any quarter. Then the cross-examination at page 6 of the witness. Please tell what is the procedure for cash deposit in the branch. MW1, the customer should deposit money after marking serial number, account number, amount of money to be deposited in pre-scroll register, and the serial number also to be marked in cash received register. Now then, tell me, now, okay, thanks. Please peruse exhibit MEX1 and tell whether pre-scrolling was done in all the voucher. Say no.
So the vouchers which were exhibited in the inquiry, it did not contain the pre-scrolling number, which is an essential part of depositing cash in the account. Then please tell SMS alert. This SMS alert is not very relevant. Now, please peruse MEX1, so and so, and tell me who has received the money. There is no cash receiver signature. So there are certain documents which does not contain any receiver signature, but the liability is on me, and I'm charged for not depositing money in the account of which I have received. Please peruse MEX so and so and tell who has received the money. In certain other exhibits, different employee had received money, but I have been charged. Please peruse exhibit so and so and tell who has written the vouchers. So the deposit vouchers, there was a specific question, who had written those vouchers? The answer is not known. Now the cross-examination over. Here, my lord will see the inquiry officer shows his biasness. There was no permission from the inquiry officer by the presenting officer to re-examine the witness. The inquiry officer on his own tells him, do you need re-examination? Then the presenting officer says, yes. Now your lordship will see the trend of re-examination. Please peruse so and tell who has accepted the other cash receipt. So whatever cross-examination was done, to negate those cross-examination, the inquiry officer asked the presenting officer to re-examine the witness. And this re-examination was done.
If we put the question, do you need re-examination?
Now, my lord,
Person from the answer is yes.
my lord,
So
lordship,
how can you attribute biasness? to the
now,
inquiry officer?
now my lord will appreciate one thing. In every proceeding, witness is examined and cross-examination is done. After the cross-examination, the one who has examined the witness may feel that I want to re-examine it. So the approach of re-examination should come from the presenting officer. Here, the presenting officer does not ask for re-examination. The inquiry officer tells him whether he will re-examine him.
No, he has not asked him or directed him to re-examine the witness. He simply put the question that do you want to re-examine?
So normally, my lord, re-examination comes from the prosecution side. Then another aspect, after the re-examination, I was not given the opportunity to cross-examine. Normally,
But did you ask for?
I did not ask, but I was not given because he has closed it. I have completed re-examination. MW1 is discharged.
Unless you ask for, why the officer will allow it?
That is why, my lord, if the inquiry officer asks the presenting officer, would you like to re-examine? Definitely, had the present inquiry officer been impartial, he would also ask the defense assistant whether you would like to cross-examine him after his re-examination. That was not done. So, sum and substance of the inquiry proceeding, lordship will see that only the deposit vouchers were placed before the inquiry officer. Now, the allegation against me is I have received money on certain dates and I have not deposited the money on the account of the customers on those dates. Now, where is the material to conclude that the money was not deposited? Because only the voucher is not the end of the material. It has to take someone to that part also where the account holder's account details should be placed before the inquiry officer to indicate, yes, on that day money was received but not deposited. And prior to that also, my lord, when there is a procedure of entering the scroll register and the scroll number is given in the cash receipt vouchers, then in all these documents, the scroll number was not given. And the branch manager did not say that the branch did not maintain the scroll register. Now, what the inquiry officer records in his finding?
Lordship will come to the findings recorded by the inquiry officers. It starts from page 38. So, my lord, this is the background inquiry order. Then this has quoted the charge. Then charge number 2, if proceedings, whatever it was placed. Then from page 41, charge number 1. Charge number 1, PO's argument. He has quoted the PO's argument. Then what is the defense argument? At the outset, this is the defense argument. At the outset, I would like to state that the transaction referred to in the charge number pertains to so and so period. This is highly improbable in diversity of truth. The charge sheeted employee has clearly stated that he did not do any act of misappropriation of money. So and so, I'll skip. Lordship will find that in respect of cash deposited in the branch on a given day, a scroll number is provided to the customer in the deposit slip by entering in the pre-scroll register, and details of the name of the customer, account holder, type of account, and account amount to be deposited is mentioned. Thereafter, the deposit slip is produced by the customer in the cash counter. So basically, what he urged in his reply, that is the argument. Now, what is the finding? After judiciously going through the argument of PO and DR and the documents presented before me, it is clear that there were 105 number of debit challenges tendered by various customers of different dates, but amount not deposited in respective account. Now, my lord, where from the inquiry officer records his finding that there are 105 deposit challenges received, but amount not deposited in respective customers' account. Because the account statement of the customer's account were not before him. At the same time, branch has not received any written complaint from customers about not depositing the amount in their account. Now, as per DR's argument, it is in the absence of any complaint from the customer's account holder in the CSE, the allegation leveled by the bank falls flat on the face of the record. In my opinion, complaint has been received verbally and MW1 has acted upon the verbal complaint. Oh, my lord, where is the material of inquiry to indicate certain verbal complaints were received? First of all, the charge sheet is totally silent about any complaint. Lordship has gone through the examination and cross-examination of the bank witness, MW1, when the presenting officer wanted to lead the witness to the complaint part, an objection was raised and the objection was sustained by the inquiry officer. So this part is not there in the evidence or the materials on record. Verbal complaint. Now, this is another thing. As per DR's argument, the fact of receiving money from the customers by the CSE could not be established in the inquiry only from MEX1 in absence of the scroll register. It is a fact that branch has not maintained scroll register. If so maintained, then this incident might have been avoided. Now, again, my lord, where is the material in the inquiry to show that the branch did not maintain any scroll register? MW1 in his evidence stated that this is the procedure. So, where from the inquiry officer records a finding that the branch has not maintained pre-scroll register? To record that finding, some material should be there in the inquiry. Either the manager should say that yes, it was not done, or the branch did not maintain that. It is from nowhere. It is his own finding, not based on the record. But But except few challans as per Exhibit 1, all the other challans are having cash received stamps with signatures and amount tendered by depositor has been written by cash receiver himself. Hence, DR's argument about this point is not acceptable. As per DR argument, the oral statement of MW1 to the extent the CSE received cash from the customers cannot be acted upon as the said witness was not posted in the branch during the relevant period. Even the branch manager who was examined in the inquiry was not there in that branch during the period of 2018 to 20. During argument, MW1 informed that he has received verbal complaints about the incident. Again, not material on record. He has issued letter to CSE to know the details. In reply, CSE given a letter apologizing for not receiving depositing amounts in their account. So the letter issued by was acknowledged so and so. As such, the article of charge is proved. Now, the article of charge is, first charge is I received money and I have not deposited in the account. In the absence of pre-scroll register, the receiving of money by me on those days is not very clear. And number two, where is the material to show that the money was not credited in the account of the account holder? Charge number 2. Deer's argument. Now, the charge number 2 is as per deposition of so and so has sought permission from the bank to allow him to deposit the money. Now, the charge number 2 was held to be proved on the basis of an admission by me. If your lordship goes to the inquiry proceeding once again, at page number 7, inquiry proceeding at page number 7, charge sheeted employee has stated before the inquiry officer at page number 7. Sir, it is my humble submission to you that as per MEX1, I don't remember not depositing amount after receiving from customer during any point of time. All the allegations made against me are false and baseless. As per MEX2, all the deposit pertaining to various accounts were deposited following due process by various customers and duly received by me and other cashiers on so and so and so and so. Moreover, none of the deposit slips were written by me. It was written by customers. As per so and so, I wish to submit that I have little knowledge about the facts and circumstances and the contents of the letter, as I was made to write down 2 number of letter under pressure and duress from the branch manager. I was forced to write without understanding the contents of the letter. So, the branch manager,
You are not late.
my lord,
You are not late.
my lord, my history is I joined the bank as a sweeper. And then after a long period of time from sweeper, I become a cashier. I made a statement in the writ petition. My initial appointment in the branch manager as a sub-staff part-time sweeper. And from part-time sweeper, my lord, after a long period, departmental proceeding examinations and seniority, I could reach that position.
That's all right, but it is not your case that you were not able to read and write.
I was under pressure. Now, even assuming, my lord, that it was done. But, my lord, I have denied the charges in the inquiry. Can the entire charge be held to be established on the basis of an admission which according to me was taken by pressure?
No, here the standard of proof is not beyond reasonable doubt. It is the preponderance of probability.
Exactly, my lord. Even for preponderance of probability, when the allegation is
Mr. Chakraborty, admitted fact need not be proved.
my lord, I did not.
Fact admitted need not be proved.
That is why I have stated before the inquiry officer that I was compelled, I was forced to write that letter. If that admitted fact need not be proved, then the entire inquiry was not at all required, since I have admitted on the basis of that admission if charge is held.
In respect of charge number one, you have not admitted.
No, this entire thing is in respect of all the charges. Admission, if your lordship takes up the finding, the inquiry officer's finding.
Page number
43, in respect of charge number 2, but the letter for all, the letter shows is that I have received money and I have not deposited. As per DSM, CSE statement has categorically stated that none of the vouchers exhibit 2 were written by him and all these vouchers were written by the customers. After going through exhibit 2, if I consider that all the exhibit MEX2 were written by the customers, but except few, all other cases, the customers did not sign as depositors. Rather, the same was signed by CSE as depositor. Where from he is getting all these materials that the CSE signed as depositor, CSE signed as receiver? There has to be some evidence. Hence, DR argument is not acceptable. As per DR, CSE was forced to write the letter so-and-so by the branch manager under pressure and duress, and he had written those letters with little knowledge of the contents and consequences. Also, also not acceptable, as CSE is senior head cashier supposed to know the contents of letter and he should not come under so-and-so. Though exhibit 4, CSE has accepted that he has not deposited cash of customers in their respective accounts due to personal problems and promised to deposit the entire money amount in the respective account, customer account. Also, though so-and-so exhibit 5, the CSE deposited money in most of the accounts and asked for some more time to deposit the balance amount. So, that admission is, I have not deposited in customer's account, I have deposited, I will deposit in some other day. That is the admission. If that is the admission, with all respect, my lord, the inquiry becomes a meaningless. I have admitted, then what remains? Other than admission, there has to be, when there is an inquiry and I deny the charges before the inquiry officer, is it not required that the charges to be proved? Though the test is preponderance of probability, but there has to be some evidence to show that I received and I have not deposited. Where is the material to show that I have not deposited? Because the account statements are not there. Where is the material to show that the customers visited the bank on such and such date? Because the debit vouchers are not having the scroll numbers. Now, why I am submitting, my lord, if this was done, even the inquiry officer finds that if it was done, then things would have been detected earlier. But he negates this contention by saying that the branch did not maintain scroll book. Now, where from he is recording that finding? The materials of inquiry does not show that the branch did not maintain scroll book. So, the inquiry officer records a finding of guilt on the basis of my admission, which I have denied. Now, on the basis of this finding, the inquiry report, I submit my representation against the finding of the inquiry officer, which your lordship will find at page 44. The inquiry officer in his report has held that both the charges against me were established. But while recording such finding, the inquiry officer has taken into account certain facts which did not form part of the materials on record, as well as ignored vital relevant facts available on record. The finding is based on some verbal complaints of customers about which nothing was mentioned in the charge sheet. They were neither examined in the inquiry nor the identity of such person disclosed in the inquiry, thereby depriving me from the opportunity of cross-examining them for my defense, resulting in violation of the principles of natural justice. So there was no complaint, and this complaint, who are the complainants, were also not disclosed. Not to speak of examining those persons before the inquiry. In respect of the finding recorded against charge number 1, I would like to state that the inquiry officer has recorded finding the branch had received verbal complaints from customers against non-deposit of money in their account and MW1 had acted on the basis of such complaint while negating my contention in the inquiry that in absence of any complaint from the bank customer, the allegations of not depositing money in the account after receiving money falls flat on the face of the record. This is perverse finding in as much as the inquiry officer in the proceedings of inquiry held on 24/5/22 had recorded the inquiry will proceed based on MEX 1 while sustaining our objection to the question of receipt of verbal complaint of customers put to MW1 by the PO. That apart, the charge sheet are also silent in respect of receipt of any verbal complaint from the customers. Even the names of persons or persons who had lodged verbal complaint before MW1 were neither disclosed nor they were examined in the inquiry. This is an afterthought which has been taken into account by the inquiry officer while recording his finding in order to negate my defense. Because in my reply, I had stated that no complaint was received and nothing was mentioned in the charge sheet about complaint. That is why the inquiry officer records a finding on the basis of some verbal complaint. Further, the inquiry officer has held that the branch had not maintained any scroll book, which is not based on any evidence placed in the inquiry by the branch bank, in as much as MW1 had not deposed in the inquiry, the branch had not maintained the scroll. Thus, the finding of the inquiry officer is not based on evidence on record and as such legally unsustainable, more so in view of the admission of MW1 that the marking of scroll number, account number, and amount in the pre-scroll register and putting the scroll number in the deposit voucher is part of the procedure for deposit of cash. It is also an admitted position that none of the deposit vouchers in exhibit MEX1 had any scroll number. Moreover, MEX so-and-so, serial number so-and-so, so-and-so, so there is no signature of cash receiver. MEX is number 1 is not the complete documentary evidence to establish deposit of cash amount by the customer in the cash counter of the bank, as well as not depositing the received amount in the respective account of the customer. So from only one deposit voucher, it cannot be held that the money that was received was not deposited in the customer's account. Presenting officer did not adduce any other evidence in respect of charge number 1, which basically alleged that I did not deposit money in the customer's account on the date of receipt of deposits from them, and as such, the finding of the inquiry officer holding me guilty of charge number 1 is not based on evidence, completing the chain of circumstances to required to establish the said charge. In respect of finding recorded against charge number 2, I would like to state that in the inquiry, no expert opinion handwriting expert has been provided or called for in respect of the handwritings of the deposit vouchers. And as such, the allegation of writing the deposit slips by me is not correct and the same is not established. Moreover, MW1 has admitted there are huge numbers of vouchers which are written by someone other than me, as the writer could not be identified. It is there in the proceedings of inquiry. The inquiry officer did not take note of these vital aspects and formed an opinion that in many vouchers, I put my signatures as depositor in support of his conclusion in respect of charge number 2. This is absolutely baseless and impermissible in law in the absence of opinion of experts, as the inquiry officer is not an expert and competent to express his views or opinion on handwritings. Thus, the finding of the inquiry officer amounts to perverse finding, as it is based on non-consideration of relevant facts and on extraneous consideration, rendering the findings unsustainable in law. Moreover, MW1 admitted that in MW2, serial number so-and-so to so-and-so, the cash was received by one Rajasri Hajarika, and in spite of such evidence on record, the inquiry officer has held that the entire charge is established against me. The inquiry officer has basically recorded his finding on the basis of my purported admission, which was taken under duress and force by the branch manager. It was specifically pointed out and explained in the inquiry the circumstances under which the letters were forced to be written by me by the branch manager. But the inquiry officer has failed to consider this aspect and recorded that a senior cashier cannot come under anybody's pressure. This is nothing but acceptance of PO's argument, as the PO in his written brief has argued solely on the basis of Exhibit 4 and 5 and tried to establish the charge on the basis of my admission. This is not legally justified. The admissions were taken under duress and force. There is no independent analysis of the evidence on record, as the bank has failed to establish the charge by way of present evidence. Now, this is what was highlighted before the disciplinary authority. Now, the disciplinary authority in the order of penalty has not given any reason why my contention should be negated. If your lordship comes to the order of penalty that is 17/10/2022, it starts from page 50. First part, first page, what is the charge? Then inquiry officers finding on charge number 1. Charge sheeted employees submission on inquiry finding on charge number 1, and then my observation. Now this is what the disciplinary authority. The purpose of giving an inquiry report and filing a representation is to point out the irregularities of the inquiry. Now, my representation may be accepted, may not be accepted, but there has to be some reason why it is not accepted, why the contentions raised by the charge sheeted employee should not be accepted. Here, your lordship will see that after recording the submissions of inquiry officers or the findings of inquiry officers and the submission of a charge sheeted employee, he gives his finding. So and so has totally failed to uphold honesty and integrity, and his credibility is in doubt. He has violated bank's norms while accepting deposits from customers without depositing to respective accounts on various dates, and thereby siphoning a huge sum of money over a period of time, bypassing the system and procedure for his bank. His reply is not acceptable. This is a one-liner answer. The questions in respect of the findings of the inquiry officer, which was raised by the delinquent employee, was not answered with reason. It fails the test of legal scrutiny. Now again, charge number 2. Charge number 2, inquiry findings, submission of so and so, and then conclusion, which your lordship will find at page 55. My observation at page 55. Charge number 2. So and so committed fraudulent activity by crediting money in so and so account on his own by writing deposit slips on his own against the misappropriation reported over 37 months from 8/8/18 to 24/9/21. This has not only breached the trust of customers with the bank and also resulted in loss of interest, so and so. Second so-called notice was given, personal hearing was done, and then the conclusion. Now, the irregularities or the procedural irregularity as well as the perversity in the findings of the inquiry officer, when pointed out before the disciplinary authority, the disciplinary authority was supposed to either accept or reject my contention. In either way, it has to be done with reasons. But if your lordship sees, there is no reason given, and the punishment was imposed. I filed an appeal. That appellate authority also mechanically rejected my appeal. The appeal rejection order, the lordship will find at page 61. This is order of the appellate authority rejecting my appeal. Page number 61. It starts from page number 61. Here also no reason is given why. Page number 61. It starts from page number 61. Here also the first charge number 1, charge number 2, then CSE submitted comments, so and so. Conclusion of the disciplinary authority, appeal, grounds of appeal, everything is quoted, and then my observation. Now here the appellate authority has also taken into account one investigating officer's report dated 2011-21, which was not even examined in the inquiry proceeding. Here also, if your lordship goes to the order of the appellate authority, the reason for not allowing my appeal is missing. Now, my lord, just one judgment I would like to refer. I had given the list of books yesterday, 2017, volume 2, SSC 308. Paragraph 7. We have given our anxious considerations to the submissions of the bar. It is true that a writ court is very slow in interfering in the findings of fact recorded by the departmental authority on the basis of evidence available on record, but it is paragraph 7. But it is equally true that in a case where the disciplinary authority records a finding that is unsupported by any evidence whatsoever, or a finding which no reasonable person could have arrived at, the writ court would be justified, if not duty bound, to examine the matter and grant relief in appropriate case. The writ court will certainly interfere with disciplinary inquiry or the resultant orders passed by the competent authority on that basis if the inquiry itself was vitiated on account of violation of principles of natural justice, as it is alleged to be the position in the present case. Non-application of mind by the inquiry officer or the disciplinary authority, non-recording of reasons in support of the conclusions arrived at by them are also grounds on which the writ court are justified in interfering with the orders of punishment. The High Court has in the case at hand found all these infirmities in the order passed by the disciplinary authority and the appellate authority. So, my lord, here in this case, lordship has gone through the order of the appellate authority. Why the punishment? Why my contentions regarding the infirmities in the inquiry report was not taken, or rather not considered at all, with reasons. The reasoning is missing. Even the inquiry officer has taken into account certain materials which are not there in the inquiry proceedings, like examination of verbal complaints. And if, my lord, at all the bank acted on verbal complaints, then it was incumbent on the part of the bank to disclose the complainant at least, and with opportunity to cross-examine those witnesses if they had verbally made any complaint. There is no written complaint of customers, but the finding is based on certain verbal complaints. Though the proceeding says that we will not go ahead with the on the basis of verbal complaint, even then, if they take or act upon any verbal complaint, then they should have given me the opportunity to cross-examine those persons who had actually made the verbal complaint. Denial of opportunity vitiates the inquiry, my lord. Now, this another 2009 2 SCC 570, paragraph 14 and 15. Indisputably, a departmental proceeding is a quasi-judicial proceeding. The inquiry officer performs a quasi-judicial function. The charges leveled against the delinquent officer must be found to have been proved. The inquiry officer has a duty to arrive at a finding upon taking into consideration the materials brought on record by the parties. The purported evidence collected during investigation by the investigating officer against all the accused by itself would not be treated to be evidence in the disciplinary proceeding. No witness was examined to prove that said document. So, because if your lordship says the appellate authority relied on some investigation report, if your lordship takes up the order of the appellate authority, this appellate authority refers to a investigating report. That investigating report was never brought on record, or the persons who made that investigation was also not examined in the inquiry. We have noticed herein before that the only basic evidence whereupon reliance has been placed by the inquiry officer was the purported confession made by the appellant before the police. According to the appellant, he was forced to sign on the said confession as he was tortured in the police station. The appellant being an employee of the bank, the said confession should have been proved. Some evidence should have been brought on record to show that he had indulged in stealing the bank draft book. Admittedly, there was no direct evidence. Even there was no indirect evidence. The tenor of the reported demonstrates that the inquiry officer made up his mind to find him guilty, as otherwise he would not have proceeded. So here in this case, the bank relied on a purported confession made before the police. And here the inquiry officer relies on a confession made before the bank official. So the Supreme Court is saying that merely on the basis of confession, it is difficult. Some evidence to show that yes, he was involved, to bring home the charge that you have leveled against him. So, summing up, my lord, here it is a case. The lordship recollects once again, the charge is I received money, did not deposit in the account. Subsequently, when it was highlighted, I deposit in a different day. So, the cash deposit vouchers by itself is not sufficient evidence to prove that entire charge. And my lord, the irregularities or infirmities of the inquiry, when pointed out to the disciplinary authority, they have not given any reason why it should be rejected. So, my lord, I'll give a reply after the bank.
May I please, Your Lord? Your Lordship, that is the inquiry proceeding dated 24/5/2022 first. That the allegations regarding that no opportunity was given.
So the school register was not produced during the course of inquiry.
Yes, Your Lordship, it has been mentioned that it is not maintained in the branch.
Where?
Yes. So once it is not maintained, then the onus has been shifted that it is maintained there in the branch.
Where it is stated in the inquiry that it is not maintained.
Yeah.
Mr. Lordship. That is the proceeding dated 24/5/2022.
Yeah.
And in the same page, that is the proceeding at page, that is at 11/30/25/5/2022, Your Lord. May I read, Your Lordship? Yes, EA said that good morning, everybody. Having assembled, let us start the today's proceeding. And EA to DR, do you have anything to say? DR to EA says that no, sir. And EA to CSE, do you want to say anything? Then CSE to EA, that sir, it is my humble submissions to you that the MEX one I didn't remember not depositing any amount after receiving from the customer during any point of time. And all the allegations made against me are false and baseless. And as per MEX2, all the deposits pertaining to the various accounts were deposited following due process by various customers and duly received by me.
and the other cashier on 10/11/2021 and 18/11/2021. Moreover, none of the deposit slips were written by me and it was written by the customer. As per MEX 4, MEX 5, I wish to submit that I have a little knowledge about the facts and circumstances and the contents of the letter. I was made to write down the two numbers of letters under pressure and the duress from the branch manager, and I was forced to write without understanding the contents of the letter. Sir, in view of the above, I pray you to kindly absolve me from all the allegations leveled against me, and I assure best of my service towards any esteemed institutions in future. Then EA2 CSE, do you feel that inquiry was conducted in a free and a fair manner and enough opportunity was given to defend your side and satisfied with the inquiry proceeding? He says, yes, sir. So at this end, he cannot say that he has not been given for cross examinations to any persons. Even at the last end, he can raise an objections. And as far as the opinion from the expert, your lordship, I have a little knowledge that whoever disputed the signature, he has to request the court to send for the, then the court cannot of its own suo motu can send the documents for the expert's opinion.
Yeah.
And in the charge one, your lordship, it is very much specifically written that the actual voucher date is 3/8/2018 and it was deposited on 10/11/2021. Your lordship, at page number 38
38 of the date
of the writ.
amount was received on.
That is, the date of the actual voucher was 3/8/2018. And it ran from 2018 till last, that is 24/9/2021. And all the amount was deposited on a single day, that is on 10/11/2020.
From where you were reading it?
Your lordship, page number 38.
Yes.
Charge number 1.
Yes.
In the Excel sheet. That is column number 5 and column number 7. That the deposit date and the date of actual voucher. That was not disputed.
Whatever disputed. Denied the allegation.
Yes, your lordship.
He has received the amount on which day?
That is on 3/8/2018. It runs from 3/8/2018 till,
Where it is mentioned?
your lordship, column number 5, column number 5 of the Excel sheet, page number 38. Date of the actual voucher.
3/8/2018.
Yes, 3/8/2018. It starts from that, and it serially mentioned. Then 24/9/2021 at page number 40, the last voucher.
So the amount was received on different dates.
Yes, it is different date.
But they
All the vouchers are of different date, but it has been deposited on the same date, that is 10/11/2021.
So the vouchers were produced before the inquiry officer?
Yes, your lordship.
Whether
It is in the
whether
MEX 2.
These vouchers are marked as exhibit?
Yes, MEX 2.
Where it is mentioned?
Yes, your lordship. I am coming to that.
Page number 2 of the inquiry proceeding.
Your Lordship, dated
Page number
start
two of the
from
proceeding.
dated 7/5/2022 and line number 8, that is PO to EA. I may be permitted to present the following documents as management exhibits in support of the to the charges, which copy of 105 numbers of the vouchers of 53 pages, which are the original voucher of the alleged misappropriate deposits, and the deposit vouchers of dated 10/11/2021, 94 numbers amounting to rupees 8,02,580, 32 pages, and dated 18/11/2021, 11 numbers of 66,802. And that fact was confirmed by the confession letter at the additional affidavit. My additional affidavit, page number 177, Your Lordship.
Yeah.
And we have issued him first the warning letter dated 3/11/2021. Thereby it has been specifically written that it has come to my notice that some customers of our branch have deposited money into their account at our cash counter at various dates and times. However, the customer finds that the deposited are not reflected in their accounts, and you have issued them counterfoil of the deposit voucher. If there are any more such cases, you are instructed to provide the list of the accounts along with the deposit vouchers and also settle all the anomalies. If any present immediately, failure to do so, matter will be reported to the higher authorities. And that was received on the very same date, and thereafter, page number 182. Sorry, Your Lordship. Thereafter, the list was provided from page number 171 to page number 181.
By whom?
By Gautam Roy on 6/11/2021.
This was submitted by him.
Yes. And thereafter, page number 182, Your Lordship. Letter dated 6/11/2021. Mr. Gautam Roy himself has written to the branch manager. May I read, Your Lordship? As per the caption subject mentioned above, I regret to inform you that I haven't deposited cash of the various customers as deposited by them in their respective account, the list of which I have attached herewith. I did the same due to my own personal problems without any influence from my colleagues in the branch. None of my colleagues and fellow staff members in the branch were made aware of the above issues by me, and the liability of the entire facts goes only to me. Sir, I am aware that I have made a grave mistakes, and I wholeheartedly apologize to you for the same. With the due permission, if given, I promise to deposit all the amounts in the respective customer's account within 7 days from today. Please consider my sincere apology for the entire situation. SD by Mr. Gautam Roy. Then, Your Lordship, the list was mentioned from 183 to 186, and it was written by in the hands of Mr. Gautam Roy. And then, Your Lordship, Mr. Gautam Roy at page number 188, this is the letter written in the vernacular language, and the type copy is at page number 187. With due respect, I beg to request you that as per the list, I need to deposit an amount of rupees 8,69,430 in 105 account numbers of the accounts. Today, I have deposited 8,02,580 in 94 numbers of account. So I request you to kindly allow me 10 more days to deposit my due of rupees 66,850 and 11 numbers of it. So, Your Lordship, it is not a case that my case is only based on the this confession letter.
these are 105 vouchers that has been drawn at a different date and deposited at the different dates. All are in the records and everything has been recorded. So findings cannot be controverted. Mere saying that I have not done so, that does not absolve him from the liability, Your Lordship. And the case of the Supreme Court is only based out on a confession before the police station. And it is nothing there on the record beyond that confessions before the bank. I think it is case of Roop Singh Negi of 2009. In that case, there was nothing on the record.
The inquiry report or the inquiry file is available.
Inquiry?
File.
Your Lordship, original file I could not able to arrange from the bank. If Your Lordship will allow, I will bring it in total.
When?
Your Lordship, 1 week to 10 days time may be given because it is in Dibrugarh. So it is quite hard for me to contact them because I have to contact first the zonal office in Guwahati. Then they used to contact in Dibrugarh zonal office.
There is a 105
5
sorts of
vouchers.
voucher.
Yes, in 2 different sets.
These are not available with you now.
Right now, not available. Your Lordship. In photocopy. Your Lordship, deposit one is with me. Your Lordship, that is the deposit that has been made on 10/11/2021 is with me in photocopy.
No,
And it,
those were deposit vouchers by the petitioner.
by the petition.
And do you have those documents by who is
The vouchers has been made at the original date. That is not available with. That is in my page number 38. What has
is
been?
it available with the bank?
Yes, it is available.
And produce those whether those are part-based activity in the departmental.
Yes, Your Lordship, might be this one be the part of MEX2.
Two.
Yes. It is.
Property.
Well,
Will keep the matter as partnered. Let them produce also.
no. I shall call Your Lordship original file.
Yes, original file.
Yes.
Original file is relating to the department.
Yes, sir.
Hardness of property and also hardness normal for the harding part will raise the matter for further consideration of after vacation.
After vacation.
After vacation. The impact so sort of self produce the entire original file. Depending on the departmental property considered against the
Your Lordship, including the inquiry proceedings.
including the inquiry proceeding.
Yes, sir. Obliged.
I think I got.
My lord, before my friend starts, let me just put a thing, my lord. I haven't received instruction, not my fault, my lord. What happened, my lord? On 23/6/25, notice was issued. There was a direction by this honorable court to serve me extra copies. Till today, I am waiting for those copies, my lord. Unless till today, my lord, I am waiting for those copies. I have checked in the file as to whether they have taken steps for the extra copies. It is not there, my lord. I haven't received any copies. Because, my lord, I can tell with lot of, my lord, conviction that I never miss to bring instructions, my lord. It's so many days wasted in between, my lord.
My lord,
Maybe,
my lord, in the order itself, it has been mentioned, my lord, that, my lord, the copies has been served, my lord. And
my lord will just, my lord,
received copies, my lord.
my lord will take up the order dated 23/6/25, my lord. I am reading the order, my lord. I know these things. Now, second page, my lord. page number 3.
Order to, yeah.
The second last para, my lord, extra copies of the petition requisite in number be furnished to the learned department council so as to enable them to obtain instructions. That is still missing, my lord. My lord,
Okay, okay.
let them, my lord.
Copy to him.
My lord, only aspect, my lord. They'll place their reply, my lord. The impugn notification that is under challenge before this honorable court, my lord. They only
First, let him obtain.
because, my lord, on returnable date, my lord, it is,
Fix a short date.
my lord, because,
Returnable date, you have not furnished copy to him, then how can he obtain?
my lordship,
There is a direction, specific direction by this court, my lord.
since, my lord, no, that Terika, it will Mr. Dhor learn extending of the response number 2, 4, service of notice is deemed to be complete in this case. My lord,
No, he has not been disputing that.
yes, my lord, extra copies, my lord. Yes, my lord.
Those I need to send it to the department, my lord.
My lord.
Will fix a short date. You
my
furnish a copy to available to him.
My lord, we'll make copies and we'll.
Also hard work. Learn something of the part. Mr. Dhar referring to the order dated 23rd 6, 2025 some extent. So there was a direction for furnishing extra copies of the petition to him so as to enable him to obtain correction. Yet the said requisite copy, said extra copies of the petition, copy of the extra requisite numbers of was not furnished to him for which he would not be able to obtain instruction. Such circumstances is provided that sir, thus learned counsel for the petitioner shall furnish extra requisite copy of the petition to Sir or during the course of the day.
During the course. Because
24 too early, my lord. 3
Lord,
weeks I will need. Not my fault, my lord. He has wasted 2 months, my lord, in between.
no,
Not my fault.
only with regard to only for the purpose of interim, if a third party interest is created, my lord. I understand, my lord. So, our mistake is there, my lord. If copy has not been served, my lord, because we.
Let us try out for that.
My lord,
will create more problem if a third party interest is created, my lord.
my lord, 25th. Just 2 matters got 24, 2 matters just got posted, my lord, today. So,
my lord,
25th.
Deeply obliged.
Item 20.
Please, my lord, in this case, my lord, TCR is received, my lord. The scanned copy of TCR is received and my lord, service report.
Service has been completed, lordship. The report has come, lordship. And
This is a POXO matter, my lord. POXO matter.
No one appeared.
no one appeared, lordship. One amicus may be appeared.
That's to be appointed.
One amicus.
Hard Mr. Gupta learned for the petition. Hard comfort. Learned additional for the state. Mr. Comfort has provided service of report of the public of the respondent of part 2, but no one entered the bidding. But the number 2 didn't contribute to the according that be a point.
In peace is also. Witness. Peace is no?
Also today. Advocate be appointed as legal counsel to represent the respondent number 2. Justice shall reflect the name of such supporting the contest and also furnish a copy of the petition and relevant documents to him well in advance. Place the matter on when
My lord, before vacation, my
before
lord.
vacation.
My lord, can you 17? Always.
May I please, your lordship? Lordship, kindly peruse the order dated 14/2/2025, lordship.
In this matter, earlier R. Muzumdar was the peer, my lord, and he handled the matter, my lord. So he is elevated, my lord. 10 days time may be granted. I am appearing on behalf of SMT 69.
Hard F. Sharma learned for third. U. Sharma learned and 6 of the so Sharma submits that this time may be granted to obtain necessary instruction. There is accordingly allowed with the matter of
24th September,
17.
17th September. Obliged.
Right, please, your lordship. Lordship, the petitioner is here, put in a very difficult situation. Why I say so, lordship? Lordship will kindly take the order which has been passed at page 33. This was a order which has been passed in the year 2023. And the directions which has been given, your lordship will find at page 40. If I may read it, lordship. The state. Item number 20.
Before I start, my lord, on last occasion, Honorable directed deposit to file the affidavit, my lord. He is out of station, my lord, and he informed me that affidavit he is preparing, my lord. So, my lord,
that is not
one week time may be granted.
No, lordship, the facts are a little different. What my learned friend is submitting.
Who will file affidavit?
The Kaushik, my lord.
These are all delaying tactics, lordship. Lordship's order, if I may point out on 14/5, lordship had passed a very specific order. That time, on that day, Mr. Kaushik was present. He has submitted fairly the due to code of conduct. Lordship will kindly take 14/5. Order dated 14/5. Lordship had find it 14/5. I'll read it for your convenience, lordship. Mr. Kaushik has produced one letter of the Director of Elementary Education, Department dated so and so, and submits that as a model code of conduct was in force, as declared by Assam State Election Commission, the final selection list could not be published. Mr. Kaushik further submits that as per his instruction, the model code of conduct will probably be lifted today, and thereafter the matter of the petitioners will be processed, and thereafter 2 weeks time may be granted. The prayer is allowed, list the matter and so. However, this lordship was pleased to record this. However, it is provided that in the event of failing to comply with the order of this court, the court may consider personal appearance of the respondents on the next day. Subsequently, lordship, 5 days have passed. Every time some other people come and say that we are complying. Now, question of giving filing affidavit does not arise. Lordship will kindly pass a speaking order as to who is present on the next day. Because petitioners are suffering for last 2 years. And lordship will remember this judgment. Lordship was pleased to pass a similar judgment wherein these candidates were applied for TET pass candidates. They approached the Supreme Court, and ultimately from Supreme Court, they have come back to this court asking for appointment. Similar judgment was passed by this lordship on contractual matters. Lordship kindly para 40 of the contempt petition. My contempt petition is 699/2023. Item number 20. 23. Page 40. Very specific directions was given, your lordship. Page 40. Page 40. I'll read it slowly, Your Lordship. The state would have the option, page 40, Your Lordship. Para 20. Page number. Find it. Specifically, 3 months' time was given, Your Lordship. The state would have the option to carry out an exercise for de-reserving the number of posts in which the present petitioners and respond number 3 to 7 are required to be considered in accordance with the earlier direction of the Honorable Division Bench in the judgment and order dated so and so, with a stipulation that such de-reservation would be later on adjusted in subsequent recruitment process. The said exercise, if decided to be undertaken, is to be completed within a period of 3 months from today. If the aforesaid option is unavailable or not able to be complied within by the state, the respondent authorities are directed to offer appointments to the petitioners after consideration of their position in the select list, and for these petitioners, including the respondent number so and so, whose positions are above my candidates who have been offered the appointment. The last of such candidates should make way for the appointment of the petitioners. The aforesaid exercise, however, is to be done by issuing a notice to the effective candidate, and appointments have to be offered to the petitioners strictly based on their position in the select list prepared in pursuance to initial advertisement dated 11/9/2020. The entire process is to be completed in a period of 3 months, as the recruitment process was initiated in the year 2020 itself. Today we are standing in 2025 September, and from last 5-6 days. Now the only thing that remains is this order, compliance of this order which has been passed by this court. But specifically, Lordship has noted that failure to not to comply, then the personal appearance of respondents on the next day.
Is out of station, my lord.
My lord, he is also appearing for the contempt, my lord. Not that B. Kaushik is alone the counsel language for the contempt.
My lord, matters pertains to my lord elementary education department, and he is.
No, it's not about elementary education department. It's about contempt, my lord. It's not representing the education department, my lord, here.
Let my lord, because it come.
The only thing that remains is that this compliance.
Next week, my lord.
How long, Lordship? How long? Because this petition has become very much affected. They are deprived. They are losing their age.
In the
last
meantime, we
2020.
will file the affidavit also, my lord. So, cost reply also filed here.
Why affidavit is required by 5?
Exactly, my lord.
No, my lord. On last occasion, my lord, Honorable Court directed to file the show cause reply.
They have not done it. They have failed it.
Because it was appeared.
Last order was.
Well, my lord, this recruitment process has started in the year 2020. The advertisement was issued on 2020. Thereafter, these petitioners were excluded from the advertisement. That's why they have approached this honorable court. Writ petition was dismissed. Writ appeal was allowed. Thereafter, they have unsuccessfully went to Supreme Court, and then this writ petitioner has been suffering till today from that position of the government.
Judgment of 2023, Lordship. On September 25, my learned friend says that they will be filing affidavit. This is nothing but delaying.
And people have not been enjoying good reputation because of this practice. One day one council will appear,
yes.
The other day another council will appear.
Well, today he is out of station, man. So I am appearing. Otherwise,
it's not the case that my learned friend has not appeared. He has appeared. He has submitted.
Yes.
Basically, he is handling the matter, madam. Because it is an elementary matter, so.
In earlier occasion also, in many occasions, he has appeared in the case.
Let the
If
director,
your lordship has checked the orders,
let the director be present on the next day.
Let my lord.
That is the only level
on next week, my lord.
The instructions will come and go, Lordship.
Yes, director may be personally appeared.
Name is also reflected in the contract.
Yes, yes.
My name is
Yes.
Yes.
Then
Basically, he is handling the matter, madam. Both the matters he is handling as because it is pertains to elementary matter.
Some amount of compassion needs to be shown by these people, the government, because they are eligible candidates, Lordship.
And
last so long years.
Next week, my lord. Next week,
Again, someone will appear on your behalf
Yes,
to make the same submission.
let the director be present, Your Lordship, on the next.
Whether this matter is being looked after by someone else and he is absent today. And do you know how many contempt cases are pending against the elementary education and secondary and higher part? More than 340, highest number in the country.
Look, they are saying is
Problem
that
either you have not communicated the order of the court to the contemptor.
The only thing now remains, Your Lordship, publication of final merit list.
orders are.
Also fails to obtain necessary instruction. And playing the game of hide and seek.
Yes.
Madam, next week may be fixed and in the meantime, Quasi will also come.
Question of publishing the final selection list, that has not been done. So director is the best person to say when he's going to publish it. Let the director be present, Lordship. And it will be an eye opener for all the cases.
No, one last chance may be given.
23 to 25, Lordship, 2 years. Lordship order was on 14/5. Then also they've got time. It's not that after next the listing is done and this prayer is made. Subsequently, twice the matter was listed. And we have pointed out this order. Then court was well in their belief they have given that time. The same prayer was made in earlier occasions also when we have showed this order. But now, Lordship, they're delaying it again, the vacation will come. Then again, they'll push it to November.
Let the contemptor number 1 and 2 remain present.
Yes,
my lord.
deeply aware.
One last chance maybe.
Several chances.
As because Quasi can also today not here, my lord.
He cannot stop from someone.
Let them present, my lord, in the next week. If possible.
That is the only
Generally,
order that
he's,
can be passed.
communicating the contempt or respondents, my lord.
Pardon?
So, my lord, Quasi communicating the respondents, my lord. So,
Causley's my learned friend name is shown clearly. If he was not present, his responsibility was ought to have taken information. He's all this.
Why you have failed to carry out the order?
That will be a very specific order, Your Lordship.
What wrong with you?
No, they are just.
It's surprising, my lord.
some verification process was going on, my lord, at that time, my lord.
Since when it is going on?
Already
Then
2-3
how
times
long-
verification has been done, my lord.
Regarding the present status, my lord, Quasi case was but I am
You do
actually
one thing.
handicapped as because file is
You-
with the with Quasi, my lord.
No, Mr. Sharma, you contact the director right now.
Yes.
You come this court after 5 minutes.
Deeply aware.
Not so well.
Otherwise, we will direct to remain present in the court on next day. You obtain verbal instruction right now. Yes, next one.
Your Lordship, there is a direction to amend the course title. There is some error in the address of respondent number 6 and 7, Your Lordship. Instead of Kamrup Metro, Your Lordship, it has been recorded as Kamrup Rural, Your Lordship. So I have, Lordship, prepared that amended course title, Your Lordship.
No, you have to file with the registry.
Lordship, we have actually it's my I tried to file it before section, Your Lordship. They denied to take it because the file is here, Your Lordship. So they denied to take it.
Part means D for a learned for the
For APSC, respondent number 3, 4, and 5.
number 4 and 5.
Standing counsel APSC.
RB goes coming for 180.
RB
Goswami.
for number 1. Next, order learned for the just for direction of the of this court. In the order dated 25, he has prepared the amended consolidated and will be filed during the course of the day. Accordingly, it is provided that this is the method after 1 week.
Monday, Your Lordship.
Pardon?
मानले नहीं बोली सर पहले
Yeah.
तो वन
One week, Lordship. Lordship, 1 week, Lordship. A date may be fixed, Your Lordship. Highly organized, Lordship. My lord,
Order has been complied with, Lordship. I received the instruction with regard to that. Composition.
I do it.
It will.
Have you informed the?
I can give you a copy.
Yes, madam.
My lordship, I'm appearing on behalf of my senior, Mr. Ayat Soikia. He is unwell, so he has to go home, but we did not know about the compliance of this order.
The promotion order has been issued.
Just now we have got this copy.
Let us place the matter on Monday in the meantime of the inspector.
Yes, my lordship.
Her name,
Anindita Deka.
Nandita Deka, Learned Counsel, appearing on behalf of Sir
Ayat Soikia.
I. Soikia, Learned Counsel. Of the respondent contempt. Sir, today has produced later dated 4th of September 2025, addressed to me by the Assistant
Administrative
Officer, informing that the order of this court has been complied with and order of this court dated 12 May 2025 passed in the petition number 13 has been complied with and the petitioner has been promoted to the post of chief engineer, to the grade of chief engineer.
Yes.
And city 1140 of the pay scale of 37,400 that grade of 10,000. Or also the less with effect from 140 by Ministry of Defense that they are ordered here, but at number MOD that we are 04130 SPD RD dash 01 dash S vacancy I dash follow grade ED dash 1 dash 12 copy of this, a copy of the letter will furnish the learned copy for the picture obtain, enable her to obtain necessary steps and to prepare this court on Monday. This is the matter on Monday at 2 p.m. The letter for the court today shall be marked as Annexure A and the date with the next.
Item 26.
Contempt matter. Matter has been endorsed to the finance department, judicial department yesterday, my lord.
When the order was passed by this court, in WPC number,
Yes, my lord. Page number 8.
okay, and when the writ appeal was dismissed,
Writ appeal was dismissed on order already provided, lordship. It is on record, lord.
Nine four 2025.
Yes, lord. 9/4.
9/4/2025.
Lordship, may I read the order, lordship, last portion, only direction part, lordship. Last 3-4 occasions they have said that whether the judicial department is required, lordship, after passing the direction, this could pass the direction, whether judicial department can revise it and review it, lord. Kindly see the direction, just one moment. Paragraph 14, page 18, lord. May I read, lord?
yes, madam. Now they have brought the ball to your court.
Yesterday they have sent lots.
Yes, sir.
Yes, sir.
Whether the department received the file.
I think the matter on witness the lordship and I have to tell instruction.
Sir, A. E. Mohammed, Garden of and also hard, sir, Khatun, and also, Respondent. Part, part, and judicial department.
Yes.
The Khatun and the court. By the joint secretary, the doctor of the part. The that file has sort part over there if the Hormone submits that the matter may be listed on Wednesday. First, Maple are of the state by creating number S6 830 this the matter on Wednesday at PM. When for Wednesday?
Problem.
The letter for the report is marked as third part.
Okay, can it be partner too?
Yes.
Yeah. Problem.
Taken up on witness day, madam. On witness day, madam.
Wednesday for?
Well, in fact, though my name is here in this matter, madam, but file is handling by Mr. B. Kaushik. Today, madam, he is unavailable. That is why I am praying. I am also there in the contempt petition as a contemptor, madam. But file is exclusively handled by Mr. B. Kaushik. Today, he is, due to some personal difficulty, he is unavailable.
Why the order could not be complied with?
Lordship, my lord, they have filed an affidavit, lordship.
No. Yes, sir.
Last occasion, Mr. Kaushik, he has filed an affidavit, madam. Today, madam, in fact, brief is not with me. That is why I am praying for some time, madam.
The Gogoi learned the here submitted not present in the court. Response submitted. Witness.
On Wednesday, madam.
There is a. Mr. Kathir said that I proceed to obtain
Obliged.
May I please, your lordship? In this case, filed a show cause reply, but the contemptor not filed a reason order till today, my lordship. Not filed the speaking order.
the contempt order.
Contemptor, my lordship, secretary to the Gopta. In the contempt petition, page number 12, my lordship, this honorable court give a direction, para number 4, page 12, my lordship. Para number 4, in view of the above, we required a petitioner to prepare an appeal under section 14 of the 17 Act before the Secretary, Department of School Education, Assam, raising there his claim for being considered for provincialization against an additional post.
My lord, yes, my lord.
Reply.
My lord, we have filed our show cause reply.
When?
It is filed on, my lord. But from then I'll check after checking.
29.
Impleadment, my lord, your lordship was pleased to allow the impleadment petition, my lord, and then directed my lord to file the cost title.
You file it.
Filed cost title.
When?
I filed cost title on my lord 22/8/2025. And Fleckberg is given there, my lord, in the office note.
Sir David?
Yes, Lordship. Lordship, here, as the present incumbent was not made, as he has added it now, instruction is there with me, which speaks that on 23rd December 24 only, a communication was made to the Deputy Inspector of Schools, seeking some clarifications, Your Lordship. So now if the department comes and they give their stand on this letter, particular letter, Your Lordship. 23rd December 2024. Let me furnish a copy to them and they may have the update upon this on the next day. A very short day may be given.
Mr. Sharma? Any instance of available in this matter?
Regarding no instruction right now. I am appearing on behalf of Disciplinary and Disciplinary. On next, upon receiving this letter.
Sir, let's elementary education department.
Deputy Inspector.
দিন
No, no, 29. Tricolora,
In the read petition, my lord, in the order, respondent number 6 was made party, Deputy Inspector Shiv Sagar, my
Deputy
Deputy Inspector of Schools Shiv Sagar, my lord, respondent number 6. Page 20, my lord.
Mr. Sharma on exit of the instruction. Part sir, if and Mota. If and part and also part every
Respondent number.
part Sharma Garden. Okay, the respondent. Okay. You can also hear it, sir. Every has produced a letter written by the Director of Pension on 23rd December 2024. The Deputy Secretary requesting to take necessary action as per the judgment of this court. Specifically in paragraph number 5 and to submit necessary report to the directorate for disposal of the matter at the earliest, but the response is still being awaited. Accordingly, it is provided that Mr. Devi has furnished a copy of the letter to Mr. Sharma, Learned Counsel, to the contender number 1, so as to enable him to take action from the Deputy Inspector of School, Shivsagar, Assam. Recital is the matter on next Thursday. Letter for the court that marked as an letter A and shall be typed with the court.
Lordship, may please reflect my name, your lordship.
Or SSL also reflect the name of Sir Devi, learned standing counsel for the respondent.
Published.
In this case, Mal, there will be hearing on 9/9, Mal. 9/9. To verify the documents of the petitioner, Mal, hearing was conducted. Notice has been issued to the Inspector of Schools, Mal, and Deputy Inspector and Block Preliminary. And they have also directed to ask the petitioner also, Mal.
I have no information.
Pardon?
I have not received any information.
Pardon, sir, your good name?
Jai Hatimuria. Jai Hatimuria.
Yeah, Demonia learned counsel for the September. Producing a letter of the director of the elementary education. Dated 4/9/2025. For us, that the director has fixed the method on 9/9/2025 for hearing. For hearing. and according to that was the matter after 2 weeks.
My lord.
This is the matter on before the and in the meantime, Mr. Bora, the complaint up to his status and appraised court on next. The letter for the court are take with the
Obliged.
31 is also same, my lord.
Yeah.
Same date, same day hearing, my lord. On 9/9.
Okay.
It is 30. I have given a notice, my lord.
Well, here, my lord, we have filed a review petition, my lord. That is pending, that is also numbered, my lord, but not listed till that, my lord. Review petition number is 101.
Order, my lord, that case number
We have
16.
filed directed to file an affidavit regarding status, my lord. We have filed a review, my lord. But that has not been, that has been listed before is honorable, but even the number is there, my lord. Well, let both review and contempt may come together, my lord.
review will be heard by the person. Heard by Sir D. Gogoi, International.
101.
Mr. Bora, Mr. Devri is here?
Yes, your lord.
The Devri for respondent number?
Director of control. Two.
Respondent number 2.
Yes.
Sir Bora, Cornet.
Case number.
Then Mr. PK Bora. Respondent number 1 and 3.
1, my lord.
3.
The 3 I am appearing also.
It's okay now for the Bora, and number that but review petition has been referred against the order by the court of or 2007 and the same yet accordingly that's what after 2 weeks.
My lord, this matter come up along with the review, my lord, that will.
No, this court cannot hear the review.
Then, my lord, the matter will go that court, lord. Even, my lord, even lawsuit take the matter, the matter will automatically go to the review court. That is, my lord, it will pending lawsuit. In the last 10 years, my lord, widow, my lord, fighting for their pension. The review will automatically go to the court there. Yeah, court along with the contempt.
No.
Review is yet.
The review listed on that particular court, my lord, this will separate, my lord. It's up to lordship, my lord. Whether lordship want to take together or not.
But let the review be registered.
Already registered and numbered, my lord. Registered and numbered. Review petition number is 101 of 2024, my lord. Only thing is that not listing the matter, my lord.
New number again
101 of 2025.
Accordingly, it is provided that that's the method. Along with review petition numbers before the third court as soon as practical.
Obliged, my lord.
Lordship, here in this matter, Lordship, in 33, I am appearing for 1 and 2, Lordship. The file has been moved to the personnel department for some views, Lordship. So the matter is under process, Lordship. Can it come immediately after vacation, Lordship? I have an instruction, Lordship.
What process proceeds?
When to the personnel department.
This is of 22/8/2025, Lordship, August.
ফটো মাৰি দিলো এতিয়া হৈ যাবে নালাগে কোন ফটো মাৰি দিলো বন্ধ পিছতে আহক মোক ৰিকুৱেষ্টটো কৰিছিল অলপ সময় লাগিব বুজিম বুলি কৈছিল
You are for the petitioner?
my lord item 33
For the petition.
SS Goswami my lord I mean SS Goswami
Yes, sir. Something that I come for the petition. For which now blood I come to the.
Both the contaminants.
So for which now commits that. So for which now producing a letter dated 22/8/2025. Addressed by the additional, written by the additional secretaries to the governor of Assam, addressing the additional, addressing the Islamic Council hierarchy part. That the letter has been endorsed to the personnel department for view, as suggested by the finance department. For views on interstate seniority of the incumbent government. Then a price for the matter after immediately after reopening of the vacancy, where is accordingly allowed on letter produced before the court to the supply marked as annexure 8. Take with that.
my lord both these cases there are two cases my lord 32 and 33 33 and 34 no
33, same.
Same my lord both these cases may come up together my lord
I am for the 34.
Okay.
बढ़िया
Please, Your Lordship, my lord, in this case, lead petitioner died, my lord. While my lord, during pendency of this case, my lord, lead petitioner died. Thereafter, my lord, the widow of the lead petitioner, my lord, filed these three, my lord, I. One is for my lord, condemnation of delay in my lord filing the connected petition for setting aside the abatement order, and second one is my lord for setting aside the abatement order and substitution of the applicant. There are three.
Whether you have served copy to the
Yes, yes, ma'am. Copy was.
Union of India.
Ke Parakh. Ke Parakh. Kamal Parakh. Kamal Parakh was the.
Oh.
Parakh my. Kamal Parakh. His name is also shown in the.
Yeah, wait for some time to inform you.
Please, Your Lordship. My lord, this is an application for substituting the legal heir of one of the petitioners who had passed away during the pendency of this writ petition, my lord. So petition number 27, he expired, my lord, and thereafter, my lord, the current incumbent, my lord, his wife has filed this application for substituting the petition number 27, my lord. She.
Number 27.
My lord?
Number 27.
Yes, my lord. Petition number 20.
Any objection?
Lordship, I have no objection regarding implement, Lordship, but I would like to submit some information, Lordship. AGCCL, where the petitioners were just in service, Lordship, AGCCL, and it was closed now. Now, Lordship, it was handed over to AIDC, Lordship, and the AIDC here in this case is not the party, Lordship. We are the industries department, Lordship. Originally, AGCCL is one of the corporation of under state government, Lordship, and after and it was closed, Lordship, and it was handed over to the AIDC, Lordship. AIDC may be the party here in this case, Lordship. He may implement the AIDC.
May I submit, my lord? My learned friend can very well argue this in the main writ petition. This is in the main writ petition, my lord. Notice has already been issued, and the parties have also appeared, my lord. So if they have any objection pertaining to the fact that the AGCCL is not existing as on date and has been taken over by some other department,
then they can very well file the objections therein and we can implead them, that's not issue. Here, my lord, in this current application, we are praying that the writ petitioner who has passed away, my lord, his incumbent may be impleaded. Yes, my lord.
Yes, Lordship.
Always argued in that main writ petition, my lord.
But
This is not an application for, my lord, any other
Yes.
purposes.
Yes.
Lordship.
Armisa, you're good.
H. Buragohai, my lord. H. Buragohai.
H. Buragohai, for the application. For the respondent.
আপনি কি application দিয়ে দেবো?
This application under order 20 section 151 of the Constitution here this is the petitioner this of the offer petitioner number 20.
Paragraph number 6 is the detail, my
Of Buragohai learned counsel for the applicant submits that the applicant submits that the writ petitioner number 27, namely Hogan Law Court suffered demise on
My lord, he passed away on 21st of May 2025.
21st of May 2025. And as such, the present applicant, who is the
wife
of the
deceased,
wife of the deceased petitioner number 27, is required to be completed in the writ petition number 604 of 2024. Additional senior government advocate, the response that is no object.
Lordship.
Accordingly, take note of the subordinate with the party allowed. The applicant namely Timothy
Biriza Lohkor, my lord. Paragraph number 6, my lord. I have stated the details. Who should be included at page 19. Yes.
Biroza Locker.
Right.
Biroza
Yes.
Locker. He impeded as party
It will remain written.
and serial number 27 in place of the
Robert Naimon.
The in of the order passed is I the third account file amended post title within a period of 1 week from today.
My lord.
Let's establish the matter after 1 week.
My lord. I'm highly obliged.
My lord, in this matter, as per my information, my lord, in this matter, several provisional lists were published thereafter, my lord, yet to be final list will be published, yet to be published, final list, because, my lord, 18-month DLA, some problem is going on, my lord, and so the final list is not publishing, my lord. Some litigation also going on, my lord, and a stay also operating, my lord, here.
Where?
I have not met such queries, my lord, but it is litigation is going on.
Going up, that is a different matter, but because of that, it cannot out the order of this court.
These are irrelevant submissions, Lordship. These are not to be taken here. All these things cannot come here.
My lord, some analysis cases is pending before this honorable court. This is not linked with this case, my lord. This is not applicable in the case. This matter has already been decided in 2023.
Let the director be present, your Lordship.
So, my lord, B Kaushik will come here, my lord, 15, my lord. So, my lord, on 15 or 16, my lord, B Kaushik will come here because he has some difficulties, so out of station, my lord.
No, that cannot be the ground because the order dated 30/7/2025 has already.
Yes, sir. Why such submissions have already been made, your Lordship? Until unless the director comes and says, the whole thing will keep on going like.
No, one last chance may be granted.
My lord, for what? Let them explain. The last chance for what, my lord?
This order has already been passed, your lordship. 14.5, lordship's order is very specific. On that day also, lordship was intending to pass order calling the director. Only because they have given a submission balancing the equity, this order was passed. That's okay, you take some chance since you are saying that it will be published. That was on me. Now we are in September. 14.5 order is very specific, lordship. And bona fide would have been of Mr. Kaushik that you have followed this order.
Or it's of in data. Or that- like, or when you are in item number 20.
My lord, I'm in 22.
22 and
I'm
23.
in
yes.
23.
And Mr. Sharma for the Sir, you Sharma learned Contempt comments that this matter was earlier dealt with by Proceeding. Not available in the court today, and as such, guys for this matter not given. However, perusal of the series of orders passed by this court, especially the order dated court 5. It appears that the matter was listed on 38/5/2025. By observing that failing to comply with the order of this court, court may consider personal evidence of the response on the next day. And thereafter, the matter was listed on 35/5/6/2025 and 28/6/2025 and 38/7/2025 and today. But no compliance order has been produced to this court. Accordingly, terms of the order dated 14/5/5, the respondent contempt notes are directed to remain present for this court on when
Another 15.
15.
Yes. In September, he will be.
The contemptor have to remain present before the court at 2 p.m.
Deeply obliged.
Deeply obliged.
In this matter, we have filed our so-called reply on 22/8/2025, my lord. And here petitioner's problem is, although enrollment is there, but my lord, in page 27 of our so-called reply. Sorry, my lord, 28.
Yeah.
However, the director of secondary education Assam issued a letter bearing so dated so wherein it is stated that from the attendance register of Lahorighat Senior Secondary School District Morigaon, it came to light that the appointment letter was issued to the petitioner, that is Mohammad Kamaluddin Ahmed, by the secretary GB Lahorighat Junior College is reflected as 24/12/2010, and his joining letter shows 27/12/2010. However, the signature of the petitioner, that is Mohammad Kamaluddin Ahmed, in the attendance register number 1 with effect from August 2009 to April 2011 is not reflected. His signature was reflected only registered 2 with effect from May 2011 to November 2012. Thus, if the petitioner's date of joining is 27/12/2010 and continuously rendering his service since 2010, then his signature should have been reflected in attendance register number 1, with effect from August 2009 to April 2011. Under the circumstances, it can be assumed that the dates of appointment letter and joining letter of the petitioner was fabricated and shown prior to 31/12/2010, and non-reflection of his signature in the attendance register number 1 with effect from August 2009 to April 2011 shows that the petitioner does not fulfill the required 6 years of continuous service as laid down under section 423 of Assam Educational Service Provincialization Act 2017 as amended 2018, which mandated that must have rendered at least 6 years continuous service as on 1/1/2017 from the date of joining in the concerned venture educational institution, which must be on 31/12/2010 or prior to that date. Further, your deponent begs to state that the Secretary to the Government of Assam, the Department of School Education, has received the spot verification from the Director of Secondary Education Assam, and soon the matter will be placed before the Joint Committee comprising the Finance Department and Department of School Education Assam for dearcation. So thereafter, my lord, necessary order will be passed. So sometime may be granted. Sometime may be granted so that government can pass the necessary order after verification of Director of Secondary Education and the Finance Department.
My lord, so page number, affidavit in show cause reply, page number 38. The petitioner filed a writ petition and claim his additional third post. And page number 12 in the contempt petition only mentioned the enrollment of the student. Already page number 38 submitted the report. Enrollment is already.
Enrollment, no problem. But regarding his
Attendance register is only for 4 months. This is not.
Time means how many times, how much time you want?
On last occasion, due to administrative reason, the joint committee meeting could not sit, my lord. So at least 4 weeks.
No. Hard is that?
And Islam.
Learn it for the. And also hard. Use or not, for the. Use or not, learn it. They cannot have already filed their reply. And that some time may be granted to comply with the order by the respondent authorities and press for the signature after 4 weeks. However, considering the facts and circumstances on the record, the norma is granted 2 weeks time. I press this court about the status of the concerned file. This the matter on public. Before the paragraph,
No objection, my lord, regarding.
article and so on, article for that. And the products or article for the conflict. This interlocutory application is preferred by the applicant for applicant under order 22 rule 3 bracket Roman 2 of the Code of Civil Procedure for setting aside an abatement order by condoning delay of 178 days on the date of one Jagadish Chandra Mehta, the petitioner in WPC number 4962 of 2023 who suffered divine so one submits that why the petition could not be filed in time? Why the petition could not be filed in time? Why there is delay of 178 days?
That is, my lord, my lord, it is discussed at paragraph 5. My lord, the engaged advocate tried to contact, my lord, to the mobile number of said Jagadish Chandra Medhi, my lord, on several occasions, as the phone was remained switched off. Again, when the engaged advocate tried to connect with the applicant on 1/4/25, then it was responded on.
Counsel for the applicant submits that due to miscommunication between the engaged counsel and also the petitioner. Petitioner already died.
Yes, my petitioner died, my lord.
Then
My lord, widow, my lord.
widow.
Yes, please.
Widow do I?
Yes, wife of the petitioner.
The petitioner does not subscribe with the legal heirs of the petitioner. And as the application could not be filed in time, and the same is not intended rather under such circumstances, Sir Rohan submits that the delay of 178 days in preparing the application may be condoned and the abatement may be settled. Mr. Parasur learned this is submits that he has no obligation. Accordingly, taking up with the burden. It's allowed. Abatement. Abatement. Set aside and file. I number 1828 part Mr. Rohan learned for the application. Or also learned learned response. This application under 5 of the Limitation Act, part 4, condonation of delay of 190. In other petition, you have mentioned it as 178. What is this?
And it was 198 days, my lord. From registry, it was clear, my lord.
Thereafter, you could have amended the petition. 190. I number 2793. This application under order part Mr. This application under order 23. The part approximately for substitution of our naming place of our visits on the place for this husband, namely City Jagadish Chandra Mehta, who died on 13/7/2024. The learned counsel for the submits that the applicant submits that the Jagadish Chandra Mehta has deferred the writ petition number 496 of 2023. And during the pendency of the petition, he suffered demise on 13/7/2023. And in his place, his widow, his wife, namely Srimati Rosmi Bedi, is required to be pleaded as the petitioner. And as such, Mr. Chauhan has contended to allow this application. Mr. Parasar noted that he has no objection. According to the of the party, the application that's allowed. The applicant, namely Srimati Rosmi Bedi, is completed as the petitioner in the WPC number 4962 of 2020. In view of the order passed by Satohan Learned Council by amended prospect with the other one.
Obliged.